what remains is that you must just focus on important issues, cover important issues in his oral evidence. And I don't think that we need more than 2 hours for that, so that thereafter I can deal with the question of what's going to happen with today's other witness. Okay, so go for the important issues so that he can cover the important issues in his oral evidence. Otherwise, everything that he has said in his affidavit is before the commission. He has confirmed it to be correct. It's there to be read.
Thank you, Chair. Thank you, Chair. That is duly noted. Mr. Craythorne, you heard that?
I did.
Okay, thank you very much. On Friday when we left off, you were dealing with the complaints that you had leveled against the mining contractors. And on page 23 of bundle number 4, that's where we stopped. We were on page 23 of bundle number 4. You indicated in paragraph 86, you say that it's only after Moodley was implicated in state capture that your contract was reinstated.
That's correct.
Do you link the two?
I do link the two because it became apparent at that point that the complaints that I had made in regard to Mr. Moodley's involvement in Scarlet Sky seemed to have reason to be concerned over.
Okay. And you end off that section by indicating that the South African taxpayers and the Richtersveld community also deserve protection from what you would describe as the wholesale theft of the marine diamonds of Alex Corp. You say this has been achieved by manipulation of the provisions of the agreements between the PSJV and the SSI and the persistent undervaluation of the diamonds produced by the contractors.
Correct.
Now, I'll take you back on your affidavit to a section we didn't deal with, which is to be found. My apologies, in the previous page, on page 18.
Page 18?
Yes. In that page, you talk about how the board of the Richtersveld Mining Company was unlawfully constituted.
That's correct.
Now, the relevance of this unlawful constitution of the mining company is what transpired at the time that it wasn't properly constituted. Is that correct?
It was during the lead up to the awarding of the tender and the launching of the tender process that it became clear to the board of Alexco as well as the joint board of the PSJV that the directors of Richtersveld Mining Company were not duly appointed. There had been a court case brought by Mr. Craig Matthews against the removal of him as the sole director of Richtersveld Mining Company, and in his place the appointment of 3 other directors who were then the directors that formed the representation on the PSJV for Richtersveld Mining Company. And I know that from a letter written by Mr. Craig Matthews to Alexco as well as Minister Lynn Brown, which flowed out of his successful court action, and that was confirmed by the Samela judgment.
Yes.
Confirmed, there was a judgment confirming that he was at that particular time, that critical time, he was in fact the only lawful in onboarding Scarlet Sky were not unlawfully, they should not have been in those positions. Mr. Craig Matthews made it very clear to both the boards of Alexcor and the board of the PSJV.
Do we have a copy of that judgment?
Yes, yes, Chair.
In this bundle?
Yes, Chair. In fact, it is on page 469 of this same bundle that we are busy with. If we can turn there.
Okay, thank you.
Thank you, Chair. Now, on this page, are you there yet, Mr. Craybon?
Almost there. I am now.
Okay. Now, in this case, we can see that this is a case that the judgment was delivered on the 4th of September 2014 by Samela J, correct? On page 469. Can you see where it says the judgment was delivered on the 4th September 2014?
Correct.
Okay, now if we can turn to page 483.
I have it.
The order is the third respondent was unlawfully removed as a director of the RMC on 22 November 2013.
Correct.
On page 469, where we last were, it's clear that the third respondent is Craig Llewellyn Matthews, correct?
Correct.
Now, the court order continues to say the third respondent, whom we now know is Mr. Matthews, is the sole director of the RMC.
Correct.
Yes. And on the very next page, on page 484, we can see that this order is being sent via email by Mr. Matthews, the third respondent, who is the sole director, to a number of people. Who are those people that he sent this court order and judgment to?
That's Serena Kellerman, Zuki, which is Zukiswa Ntlangula.
What are their roles? Sorry, when you mention a name, can you tell us who that is?
Okay, Zarina Kellerman was the Chief Legal Officer at Alexcor Corporate.
Yes.
Zukiswa Ntlangula was a board member of the Alexcor SOC board.
Yes.
Reagan Phillips was the company secretary of the PSJV.
Yes.
Dr. Roger Paul was a board member.
Of the JV or of Alexcor?
Of Alexcor. And he was also a board member of the joint board.
Mm-hmm.
Percy K, that would be Percy Causa, who was the CEO of Alexcor at the time.
Yes.
Dr. Nona Mahutua Matabani, I'm not sure what her position in the company would have been. And then lastly, Mr. Mervyn Carstens, who was the Chief Executive Officer of the PSJV.
Yes. And if I may refer you also to page 400 and my apologies, I've lost my page, Chair. If the Chair will just bear with me. It's actually the very next page, 485.
I haven't.
Okay. And on this, in this document, this is a letter addressed from the Richtersveld Mining Company to the directors of Alexcor and the CEO of the PSJV and the board secretary of the PSJV, dated the 4th of September, correct?
Correct.
And we can see that in this letter, Mr. Matthew is communicating the content of the judgment.
That's correct.
And what does he say on paragraph 7, which is on the page 486?
Paragraph 7 reads as follows. The further implications are very serious in that any decisions that were taken by the PSJV board since November 2013 are on the face of it invalid for the mere fact that the Richtersveld Mining Company representatives were not appointed by the RMC and had no authority to take decisions on behalf of the company and the PSJV board. You were advised in previous communications that subsequent to the finalization of the aforementioned court matter that the RMC may review all decisions taken by the PSJV board since November 2013.
Yes. And if I move you on to page 490, 490,
Yes?
what document is that?
This is an email or a letter transmitted by email from Mr. Craig Matthews. Oh, no, sorry, it's addressed, sorry, I beg your pardon. It's a letter sent to Mr. Craig Matthews from Alex Gore.
Yes, and what's the subject line?
Western Cape High Court matter.
Now, this seems to be a response to the letter that had been sent by Mr. Matthews, correct?
That's correct.
And in paragraph 2, together with 2.1, what does it say there in that letter?
It starts with, as far as we do, however, note the following. Neither the company nor the PSJV were parties to the court action referred to in your aforementioned letter. And as a result, the attachment of the court's ruling as well as an expose of the court action is of no consequence to us.
Now, what do you make of that response from Alex Gore?
I think it's a reckless disregard for good governance and for the High Court.
And in fact, I can take you further to page 495 of the same document.
You mean of the same
Of
bundle?
the same bundle. My apologies, Chair.
I have it in front of me.
Now, we can see that this is a letter on the letterhead of Adams and Adams.
That's correct.
And it's dated the 5th of November 2014.
That's correct.
It's addressed to Mr. Bachas, but with a wrong spelling.
Correct.
Okay. Now, if I can just refer you to, well, they confirm firstly that they act for the Richtersveld Mining Company, and they are writing the letter at the direction of the sole director, Mr. Craig Matthews.
Correct.
And then in paragraph 4, they also confirm that on considering your correspondence regarding the judgment, it's apparent to us that you are under the mistaken belief that due to not being a party to the proceedings, the judgment is of no consequence to you, despite the central issue in the judgment being the directorship of our client. And then they go on to address this, what Adams and Adams refer to as the mistaken belief. Do you see that in paragraph 5?
I do.
Yes. And they say in paragraph 5.2, the fact that Alex Gore was not a party to the said proceedings is irrelevant. The decision-making process of the PSJV presupposes that the directors of our client were validly appointed and or validly removed. And it sets out what the judgment says.
Correct.
Yes. So, if we turn further to page 497,
I have it in front of me.
yes, in paragraph 5.4, do you confirm that it says, although our client accepts that you and the Community Property Association are co-signatories to the settlement agreement, your primary contractual obligation in terms of the settlement agreement and the unanimous resolution are to our client and his correctly appointed board of directors?
Correct.
Yes. And in paragraph 5.5, what is the last thing that they mention?
Our client is particularly concerned by your failure to appreciate the potential for all the decisions taken by the PSJV from 22 November 2013 by an improperly constituted board to be rendered null and void. This is illustrated by your persistence in engaging the purported directors. Despite the court order, and accordingly, there is a very real danger that the PSJV may be exposed to damages claims in respect of contractual arrangements concluded with third parties after 22 November 2013.
Yes. And we already know from your evidence that what had transpired in this particular period was that there had been a decision that was taken to appoint, to go out on tender for the appointment of a service provider for the sale of diamonds.
That's correct.
Okay. Now, we note that we don't have a response after that letter. Immediately after that letter. Oh, please correct me because I am wrong. On page 499 is a response. Mr. Craython, if I'm wanting you to confirm something that's incorrect, just bring me to order.
I'll do so.
Yes.
Thank you.
And on page 499 is a response dated the 7th November 2014 from?
It's from Alex Gore, and it's addressed to Adams and Adams. Attention, Mr. A. Mulver.
Yes. And who is the author of the letter on page 500?
Ms. Zarina Kellerman.
Yes. And in this letter, does Alex Gore accept the position as set out in the letter of Adams and Adams? Do they even deal with the merits of what was in the letter from Adams and Adams? I'll take you through to paragraph 4.
Yes, ma'am.
They say that we place on record that Alex Gore has never pronounced or actively supported any factions in the Richtersveld community. It has, through its obligations, supported the legitimately elected structures created in terms of the deed of settlement concluded between the government of South Africa and the people of Richtersveld for the full and proper implementation of the deed of settlement. And in paragraph 5, they say, Alex Gore has no authority over the affairs of the Richtersveld Communal Property Association or its subsidiaries. We refer you to, and they refer to a judgment that deals with that. And
Correct.
then they carry on in paragraph 6, and they say, we are advised that your client was removed through proper resolutions by the majority shareholder of Richtersveld Mining Company. Now, is this correct given what the judgment says?
Well, that shows utter contempt for Judge Samela, in my view.
Because isn't what the judge in fact said isn't what the judge in fact say the exact opposite of this assertion?
That is correct. They're contradicting Judge Samela.
Now, that is the last of that at that stage, and that's in November. That's on the 7th of November, 2014.
That's correct.
Now, you've already given evidence that on the 6th of November, what had been done by SSI and other companies?
They had begun competing to win the right to market and sell Alex Core's diamonds by way of the request for proposal 03/14, I believe it is.
Yes, and SSI had in fact on the 6th submitted their show of interest or expression of interest.
That's correct.
So as at the date when this letter is being written by Alex Core, the process is ongoing.
That is correct.
Yes. And a few weeks thereafter, you've already testified, as has Mr. Torres, that the proposals were in fact received by the PSJV, and the PSJV continued to evaluate and take the necessary steps without the involvement of Mr. Matthews, who was the sole director at that time of the RMC.
That is correct. So the whole tender process continued regardless of the implications that Mr. Matthews had raised.
And what did this indicate to you?
This indicated to me a total lack of accountability or sense of probity in relation to corporate governance.
And in fact, we know that, or we can see, let me take you to page 501 of the same bundle.
I have it before me.
Yes, and what is that document in front of you? It's a letter?
It's a letter addressed to Minister Brown on the 25th of February 2015. And it is authored by Mr. Craig Matthews.
Yes, and what does he say is the purpose of the letter in paragraph 2?
He states the following: the purpose of my letter is to bring to your attention the recent developments within the RMC and to raise my concerns regarding Alex Core's attitude to these developments.
And in paragraph...
Mr. Bear, will you make sure that page 502 is replaced with a page that is along the same lines as page 501. On my bundle, 501 is fine, but 502 is the opposite of 501 in terms of how it is placed here.
I understand.
It's I don't know what happened to the person who was putting them in. So if you could have that corrected.
Thank you, Chair. We'll attend to it. Now, on page 501, in paragraph 5, Mr. Matthews indicates that as regards Alex Core's response to my attorney's letter, you will note, yes.
You see, paragraph 5 on mine is at page 502, not 501. Is yours on 501?
Yes, Chair, then we
Yeah.
definitely need to correct that.
So we should all have exactly the same
Yes.
thing. When you say paragraph 5 at page so and so, I should find paragraph 5 on the same page.
Yes,
So,
Chair.
my paragraph 5 starts with "in view of the aforesaid." Is that your paragraph 5 as well?
Sorry, Chair?
Does your paragraph 5 start with "in view of the aforesaid"?
No, Chair. I think we might even be reading two different documents as things stand.
Yeah, yes, and that makes it even worse then.
Yes.
The letter that you referred the witness to, you said appears at page 501, is that correct?
Yes, Chair.
And when you say 501, okay, maybe we are, or maybe I am the cause for the mistake here. You are using black numbers.
Yes, Chair.
Oh, okay, no, that's fine. I think where we have a bundle that has got both red and black numbers, we must always, at the start of the process, just confirm that it's the black numbers we are using. Okay, so you are at black 501.
Yes, Chair.
And your paragraph 5 starts with "you, as you will no doubt agree." Is that right?
Correct.
Then I'm reading the wrong paragraph.
That's a wrong paragraph.
Because I meant to read paragraph 6. But I agree with
Is
what
it a
the
letter
Chair...
addressed to the Minister of Public Enterprises,
It's the same document, Chair.
dated 25 February 2015?
Yes, Chair.
But you say your paragraph 5 doesn't start with "as you will no doubt agree."
No, Chair. I'm confirming that that's how paragraph 5 starts.
Yeah, okay, no, that's
Yes.
all right.
But
Then the comments I made about 501 and
Yes.
502 earlier on the 2 pages, they relate to red 501 and red 502, but 502 still requires to be replaced with a page that is in line with page 501.
Yes, Chair.
Okay, all right.
Unfortunately, we'll have the same problem on another page in the future, but I've noted that page as well.
Yeah, okay,
Yes.
all right.
Thank you, Chair. Chair, what I was in fact saying was that I've referred the witness to the wrong paragraph number. Yes, because I
Okay.
want him to read paragraph 6.
Paragraph 6.
Yes, on
Okay,
page
all right.
501.
Okay, paragraph 6 at black 501.
Yes.
Okay.
As regards Alex Core's response to my attorney's letter, you will note that despite our concerns that the PSJV would be concluding transactions which may potentially be invalidated, Alex Core sought to disregard this issue as merely an internal issue within the entities controlled by the Communal Property Association.
And the next page, next paragraph.
Going on to paragraph 7, the obvious difficulty with Alex Core's attitude is that it has left the PSJV exposed to potential damages claims as the contract is entered into may potentially be invalidated due to the PSJV board having regard to and acting on the instructions of persons not authorized to bind the RMC.
And from what you know, did anything happen? Was there a response to this letter? It's not addressed to you or by you, but I'm asking from you the investigations you made. Was there a response to this letter?
As far as I'm aware, there was no response from the minister to this particular letter.
Yes. Now, on page 30, sorry, 503, GC 30. Black 503.
Okay, so it's black page 530.
No, I can see you're on the wrong page.
Sorry, I beg your pardon.
503.
503. Dyslexic, I'm sorry. Okay, I'm at 503 now.
Yes, this is another letter from Adams and Adams addressed to Mr. Bachas, correct?
That is correct.
And it's dated the 27th February 2015.
Correct.
And among the requests that are made in that letter is a request on paragraph 5.5, which appears on the next page, which is 504, which is the page that we will correct.
Okay. So that's 504 on the black numbers?
Yes.
Okay.
And one of the requests that are made by Adams and Adams is in 5.5, and what does it say?
It reads as follows: hold over all further decisions of the PSJV until a properly constituted board of the PSJV, that includes our client, has had an opportunity to reconsider these decisions.
And if I may refer you to page 259 of this same bundle.
On what page?
259, Chair.
Okay.
This is the middle of a document that starts on page 253. Can you go to page 253 so that we identify what the document is?
I'm at page 253.
Yes, what is this document?
This is a covering letter addressed to Honourable Minister Ms. Lynn Brown, reporting back on the investigation carried out by the Exco Audit and Risk Committee in relation to the appointment of Scarlet Sky.
Yes. And the date of the document?
29 February 2016.
Now, if we go to page 259,
259.
yes. Towards, on the left-hand side of the table that appears there, you will see at the top it says left. In the left column it says date, and in the middle column it says description, and in the second to last column it says annexure, and in the last column it says reference to collaborative evidence, correct?
That is correct.
So this is a report to the Minister, Ms. Lynn Brown.
Correct.
Now, at the bottom of that page, the very last entry, what is the date on that entry?
That is the 1st of March 2015.
Yes. And in the description, what does it say happened on the 1st of March 2015?
SSI was informed that they were the successful bidder and that the tender was awarded to them, and all other companies were informed that their proposals were unsuccessful.
So this is 2 days after the letter from Adams and Adams saying, please hold over all further decisions.
Correct.
So they completely disregarded that warning,
That is correct.
in addition to disregarding the judgment itself.
Correct.
What did this communicate to you, these actions, in spite of the judgment and in spite of the warnings?
Well, I again repeat, it indicated to me that there was an absolutely total disregard for due process, for honesty, for good governance, and that this was typical of what I understood to be state capture at play.
Now, if we can go back on your affidavit to page 44.
Just before that,
Yes, Chair.
Mr. Craython, the members of the Alex Audit and Risk Committee who produced this report, to your knowledge, how many of them could be described as Gupta associates?
At least one,
Yes. Who was that?
and that was Mr. Trevor Harsbrook.
Yes. Okay.
Thank
Yes.
you, Chair.
Continue.
Thank you. If we can go to page 44 of the same bundle. Your affidavit.
I'm at page 44.
Now I'm taking you to the heading that you have titled State Capture.
I have it in front of me.
Okay. Now, in this section, you tell us the background to the report that we've just had a look at. And you indicate that there had been a complaint to the public protector and that this report was as a result of a reaction to the complaint to the public protector.
Correct.
What was the complaint to the public protector and who had made it?
It was a complaint authored by Attorney Duncan Karabi on behalf of the Richtersveld community, objecting to the absence of a due diligence prior to giving the contract to Scarlet Sky, and then also in relation to the lack of transparency and the lack of performance on the part of Scarlet Sky.
Yes. And if I can take you to bundle 4B.
Ms. Beer, just before you do that, do you recall whether in the report of the Audit and Risk Committee, to which you referred a few minutes ago,
Yes, Chair.
whether in their report that committee said there had been a due diligence that was conducted?
They say that, Chair.
They
We're
said
still
that.
going to go there, but yes, they say
Okay,
that, Chair.
okay, all right.
Yes.
Thank you.
Now, in bundle 4B, if we can open page 815, 815.
I have it in front of me.
Yes.
What's the page number again?
815.
Okay.
Is this the complaint you were referring to, Mr. Craython?
That is correct.
So it's the complaint to the public protector for the attention of Ms. Winnie M. at pprotect.org.
Correct.
And what does it say the complaint is in the heading?
Complaint, irregular awarding of contract to Scarlet Sky Investments 60 Pty Limited and Flawless Diamonds.
Yes. And if you turn a few pages to page 818,
I have it in front of me.
you can see who's the author of the complaint.
Duncan Karabi.
Yes, and he calls himself an independent director, correct?
Correct.
Of the Richtersveld Mining Company.
Correct.
Okay. Now, if we turn the page to page 819, and we look in the middle of the page where it says begin forwarded message, can you see that? In the middle of the page.
It's 819. Okay, I have it. Yeah,
You see it.
I do.
And there is where we can see that this document was sent via email, because this is where it says from, and it has the email address of Duncan Kurabi, and to Winnie, and has that email address, and it tells us the date and time. What is the date and time of this complaint?
It's 11 September 2015 at 13:35.
Yes. And if you look at the top of the page, you can see that this message is forwarded to other people. Can you
Correct.
see that?
Correct.
It's sent from Duncan Kurabi at 1:44 p.m. on the same date, correct?
That is correct.
And who is it now sent to?
It's it's sent to Percy Causa, Percy
Yes.
K at alexcore.co.za.
And you've said this was the CEO at the time.
That's correct.
And who else was copied?
It was copied to Katatso Tlakudi at dpe.gov, Mervyn Carstens, Mervyn C at alexcore.co.za,
You don't have to read the email addresses, just the names of the people.
Zarina Kellerman, Dr. Roger Paul, the Richtersveld Communal Property Association, Mr. Willem Vries, Mr. Dennis Farmer, Mr. Pieter de Wet, Mr. Joshua de Wet, and Ms. Catherine Slander.
So many people were given this email. And what does it say to Mr. Koza?
Dear Mr. Causa, please find attached the RMC complaint to the Public Protector related to the appointment of Scarlet Sky Investments 60 Pty Limited. I apologize for not forwarding the document to you yesterday, but I only returned from a business trip yesterday evening and could only attend to finalizing the complaint today. It is unfortunate that we have to refer the matter to the Public Protector, but we do not have the cooperation of the Executive Committee on this matter, and we are strained in our access to the information. We trust the above is in order.
And if you look at the next page, page 820, you can see there's another email dated 2018 July. Can you see that?
Yes?
Who is it from?
It's from Duncan E. Karabi.
Yes, and who is it addressed to? Which entity is it addressed to?
To Charmaine Issel at DPE.
Yes. And what does he say was the outcome of the complaint?
Dear Charmaine, please find attached the original referral of the complaint. There was some additional information sent. Let me know if you want that. The complaint was registered with the Public Protector under reference, our reference ref :7/2-011497/15, Mr. D. Korabi. In November 2015, we agreed, following a meeting between the CPA and the Minister of Public Enterprises, not to proceed with complaint to allow her to investigate the matter internally. We agreed that the ARC committee of the PSJV would investigate the matter. Later, I discovered that Zarina Kellerman tried to investigate the matter herself. To the best of my knowledge, the matter was never investigated. There was a separate complaint against Kellerman. Let me know if you would like that as well. Regards, Duncan Karabi.
Yes. Thank you. You can put that bundle aside for now as we go back to bundle 4A. If I can refer you in bundle 4A to page 260.
I have it in front of me.
Yes. You confirm that this is still the report made by Alex Core to Minister Lynn Brown?
I confirm, sir. Yeah.
Yes. Now on page 260, we can see a heading marked 4.2.2, the response to the complaints by the committee.
Correct.
Now they start responding to the issues raised.
I'm sorry, I thought you said page 206. That's not right, eh?
No, it's 260.
250.
260. Yes.
Okay.
Yes, Chair.
Okay, continue.
Thank you. So the gist of the complaint starts in in what they say, para 2. Do you see that reference in the box that's in the table that's below the heading response to the complaints?
Correct.
Yes. And it says, on the 17th of December, the previous chairperson contacted Korabi and required him to approve the conditional appointment. Certain queries were raised surrounding the appointment, and he persisted that a conditional appointment be done. Inter alia condition of the appointment of SSI was that the CEO should conduct a due diligence on SSI and report back to the committee on such due diligence.
Correct.
Can you see that?
I do.
So that is the complaint.
Correct.
Yes. The response by the committee is that Mr. Korabi, who we know is the author of the complaint, right?
Just to make sure that we've captured this in the transcript, you are now dealing with the Audit and Risk Committee report that starts at page 253, is that right?
Yes, yes, Chair.
Yeah, okay, all right.
Thank
So the response is, to the complaints, is a response by that committee. Is that
Yes.
right?
Yes, Chair.
Okay,
So it's in a way their findings,
yeah,
having investigated the issue raised
yes,
by, to the public protector.
okay,
Yes. So in terms of their investigation, Mr. Korabi did not raise any concerns regarding SSI. The only committee member who had further comments in his email was Dr. Paul. Can you see that?
I do.
Yes. And it says it was confirmed by the chairperson that the reason the approval was conditional was to ensure that all concerns of the committee were addressed, even though SSI had attained the highest scoring.
Correct.
Yes. And then in paragraph 3, or where they say para 3,
Yes.
they record the complaint as, it would appear that there could not have been much due diligence. SSI was previously owned by Legal Frontiers Corporate Services, which is a company that trades in shelf companies. It would appear, now on page 261, it would appear that from 2009 to 2014, SSI was a shelf company owned by LF. LF sold SSI and its new directors were registered on 20 November 2014. We do not know who the shareholders are.
Correct.
What is the response by the committee?
It reads as follows: the CEO of the PSJB did a proper due diligence on all the technical aspects and submitted the report to members of the tender committee in an email dated 29 January 2015.
Yes. Does this tell us the nature of the due diligence that was conducted?
It claims to be a purely technical due diligence,
Now, based on the evidence you've already given, could a due diligence on the technical aspects resulted in the continued appointment of SSI?
No, it could not have.
Why do you say that?
Well, because the absence of a license on its own was enough to trigger the expulsion from SSI from the process.
And we've already dealt with, in your evidence on Friday, with the question in relation to the experience.
And numerous other specifications which were minimum requirements in the tender specification, which SSI failed to meet.
So we don't know why they would say, why the committee would give this response.
No.
But is your evidence that there was no due diligence that was done?
I have not seen any evidence whatsoever of any due diligence report.
Yes. And the committee itself did not attach such due diligence report to its report, did it?
No, the only thing that I think is being preferred as a due diligence report was a mere email from...
Obviously, that can't be what one is talking about when one talks about a due diligence that must be conducted before you make this kind of appointment.
And even the email offers no assurance, which is what the purpose of a due diligence is.
Yeah, and I guess the first thing that would have been discovered would be that this company had no license.
Correct, Chairperson.
The question that arises is whether there is room for saying that the Audit and Risk Committee, in preparing this report, acted in good faith, or whether they included in the report false information, knowing it to be false. Are you able to say anything about that?
Chairperson, these are people with PhDs.
Yes.
And I fail to see how anybody with a PhD can mistakenly mistake what might possibly have been preferred as a due diligence. I can't see it.
Yes, yes. And their report does not say anything about SSI not having had a license, or does it?
I would have to refresh my memory, Chairperson, but there is no report. There is merely an email from...
No, I mean the committee's own report to the minister. I'm saying, does their own report to the minister, the Audit and Risk Committee's report, say anything about SSI not having had a license?
No.
Yes.
Not to my recollection,
Yes.
Chairperson.
And it's just difficult how they could have investigated without establishing that simple, basic fact.
I agree.
They either must have turned a blind eye, or they were simply not prepared to include that in their report.
I agree, Chairperson.
And it's difficult to understand how they could do that in good faith. Maybe they will explain. Ms. Bia?
Thank you, Chair. If we continue on page 261, and I'm taking you to the bottom of the page, the last block, and on the left it says para 6.
I have it before me.
The complaint is, prior to the sitting of the tender committee, no documents were made available related to the candidates who would be considered to Korabi. Sorry, let me read that again so that it makes sense. Prior to the sitting of the tender committee, no documents were made available related to the candidates who will be considered, such report being made to Korabi. So Korabi did not get any documents. And it says, prior to the interview of the shortlisted candidates, the tender committee did no shortlisting, and the tender committee had no insight into the methodology and process used in the shortlisting process. In an email response, Reagan Phillips mentioned that the CEO will speak with Korabi prior to the meeting. No such discussion took place. Individuals in the PSJV did the shortlisting. Amongst other, we discovered the CEO and the secretary were part of that. The CEO also sat in the shortlisting interview process on the 11th of December 2014.
Correct.
The response by the committee says, Gamiro Advisory Services was appointed to conduct the exercise of shortlisting. The committee acknowledged that the presentation by Gamiro Advisory Services should have been accompanied by a report that informs the committee of the methodology followed and the process used to shortlist the company. This matter will be highlighted to the management of the PSJV to enhance controls around reports received from external parties.
Correct.
This response by the committee, does it tally with the evidence that we've heard already or from what you have investigated? That Gamiro Advisory Services were appointed to shortlist and that there were shortcomings in the presentation made by Gamiro Advisory Services?
I agree with that.
Now, do you know whether the presentation by Gamiro Advisory Services identified any shortcomings?
It certainly did in relation to the license.
Yes. And also the scoring.
And well, the scoring on the license portion of the evaluation, where Gamiro scored 0, the bid evaluation committee themselves altered that from 0 to 5.
Sorry, which committee?
The tender committee, which finally ultimately awarded the tender to Scarlet Sky, altered the scoring which Gamiro had placed on SSI in terms of the license from 0 to 5.
And interestingly enough, we've already heard evidence that SSI was scored 100%, but the person that scored them is the same person that made this report to the public protector.
That is correct. It's rather curious, but it is correct. And while the other scores given by Mr. Bacchus and Dr. Paul were way lower than Mr. Korabi's scoring, they were in any event the highest score amongst the three. So all three of these gentlemen scored Scarlet Sky the highest. So it was a unanimous decision.
Do we have Mr. Korabi's affidavit explaining his conduct that seems inconsistent in this regard?
We don't, Chair.
Why not?
Chair, that is part of the process that the investigating team is still undertaking.
Oh, but that should have long been done.
I
It's such
confirm
an-
that.
He is obviously such an important witness. I mean, he makes allegations about how he was conducted by the chairperson who told him or instructed him that they should approve or award the contract to SSI, and then he seems to lay a complaint with the public protector about exactly that. And as Mr. Crathon says, he awarded SSI a lot of points. So that is somebody that should long have been interviewed and an affidavit obtained. Do you know how far we are from having his affidavit? I mean, how far we are in getting his affidavit?
Chair, the next steps are being planned as we speak, as we prepare as we present the evidence.
No, I know
In
that
securing his affidavit, because there were engagements with no response. So we are looking at the next steps, Chair.
I know that you only got involved in this work stream recently, but I have been told for a long time that everything was ready with regard to the leading of evidence of Alesco. And I thought that all important affidavits were in, and Mr. Korabi's affidavit is quite important.
Chair,
Yeah, you can't say much.
yes,
Yeah,
yes.
okay.
But it was identified since my involvement as one of those that need to be obtained.
Yes.
Chair.
And do you know what the position is with regard to Mr. Bakas? Has he been interviewed? Is there an affidavit that has been obtained from him and Mr. Custons?
Sorry, Chair, I missed the first person.
Mr. Bakas.
As things stand, Chair, there's interaction with the legal representatives, both of Mr. Custons and Mr. Bachas. There has been a lot of communication. There had initially been technical issues raised in relation to the admissibility of this evidence that was raised in relation to Mr. Bachas by his legal representation. So we are in engagements with them, but they have not submitted an affidavit.
But if he is not cooperating, he should just be served with a 10-6 directive requiring him to furnish an affidavit, and he would then be obliged to comply. We mustn't be wasting time. We don't have time.
Yes.
His lawyers may be taking whatever point. We'll see what points they take. But if we need information from him, we can't be engaged in an endless toing and froing process. If the legal team believes that he has information that is required by the Commission, he must be served with a 10-6 directive and be given a deadline. We don't have time to waste.
Chair, I will make sure that that is attended to this week.
Yeah, and Mr.
Yes.
Custons, has he been interviewed? Do we have an affidavit from him?
Mr. Custons submitted an affidavit last week. It does not deal with the substance as such. It explains his delay in responding and other matters. He has not been well. He is in isolation as things stand. Ms. Phillips, Reagan Phillips, is presenting her response together with Mr. Custons, and they are legally represented.
Yeah. what should have happened is that by the time we lead the evidence, all the important affidavits should have
Yes.
been obtained, including the affidavits of those people who may be seen as implicated persons. We should
Yes.
have their version, we should have their side of the story. That should have been done. And when I was told that the Alexco evidence was ready, I thought that it would have included, that meant that the affidavits of all the important witnesses were in. Okay, let's continue. But before we do that, Mr. Craythorne, I want to take you back to page 260. That is still in the report of the Audit and Risk Committee.
I have it before me, Chairperson.
Yes, and I'm taking you to a portion that Ms. Bia did take you to, but I want to canvass a slightly different point. Can you see where it says paragraph 2?
Yes.
Yeah, then it says, and that's a recording of the allegation or complaint. On the 17th of December 2014, the previous chairperson contacted Korabi and required Korabi to approve the conditional appointment of Scarlet Sky Investments 60 Pty Limited. I raised certain queries with him surrounding the appointment, and he persisted that a conditional appointment be done. Inter alia condition of the appointment of SSI was that the CEO should conduct a due diligence on SSI and report back to the committee on such due diligence. You have read the response of the committee, which comes immediately after that, haven't you?
I've read the response.
Yes.
Yeah.
Does it deal with the factual allegation of that Mr. Korabi was contacted by the chairperson who required Korabi to approve the conditional appointment of Scarlet Sky Investment?
Well, what it appears to do is it appears to simply say that Mr. Korabi requested a due diligence, but it doesn't answer the question of whether due diligence was done or not.
Yes.
And Mr. Korabi, in protest, resigned from the board.
Yes, no, but that's a separate issue. All I was asking was whether this committee, faced with an allegation that the previous chairperson had contacted Korabi and required Korabi to approve the conditional appointment of SSI, whether in its response this committee responded to that.
No, I don't see.
Yes. Do you know of any reason why they would not have, in their investigation, contacted the previous chairperson and found out whether this allegation about him made by Korabi was correct?
Well, it seems to me, Chairperson, that there was no rigor at all in doing this, investigating and doing this report.
Yes. Okay. Ms. Bia, continue.
Thank you. On page 262, we see where it says para 7.
Yes.
The complaint is the PSJV subscribes to the Public Finance Management Act 1 of 1999, at least according to the CLO, Chief Legal Officer.
Correct.
And the response by the committee is the JV is not legally obliged to subscribe to the PFMA. However, it does subscribe and adhere to the PFMA through its association with a state-owned company.
Correct.
Yes. And then on the next point is, on the 11th of December 2015, the CLO and chairperson at the time took Korabi and Dr. Roger Paul, an Alex Corps representative, into his office and discussed what he viewed as the new direction the PSJV must take in appointing the service provider. He mentioned that only one candidate will be interviewed, only one candidate that will be interviewed met the new direction he proposes. He then mentioned SSI. Do you see that complaint?
I do see that.
And what's the response by the committee?
The date 11 December 2015 cannot be correct as the tender was awarded on 27th of February 2015.
Now pause there. That's correct, hey? It should be 2014.
Correct.
Yes. And then what do they continue to say?
We have received the representation of Mr. Bacchus that he has no recollection of the meeting taking place.
Similarly to the question that was posed by the chair previously, does this deal with the substance of what was said to have been said at the meeting?
It sheds no light on the matter at all.
Yes.
What does CLO represent again?
Chief Legal Officer, that's Ms. Zarina Kellerman.
So therefore, the CLO and chairperson would be two different people.
Yes, Chair.
And in their response, they talk about what Mr. Burgess said, but they don't say anything about what the CLO said, isn't it?
Indeed.
The CLO would have been a different person. Is that right, Mr. Craythorne?
That's correct. Mr. Korabi is alleging that he was briefed by, amongst others, Mr. Bacchus, and Mr. Bacchus states that he has no recollection of a meeting with Mr. Korabi having taken place.
And also, from this, it looks like after they had talked to Mr. Bacchus, they didn't go back to Mr. Korabi and say, he says he can't recall. What can you say to jog his memory?
And the matter is left there.
It's just left there.
Yeah.
He doesn't remember, but here is somebody who does remember. But it's just left there. And then the CLO, they decide not to check with the CLO, particularly in circumstances where one of the parties says, I can't remember. That was all the more reason why they should talk to the CLO and say, do you remember?
Correct.
But they didn't bother to interview the CLO.
That is correct, Chair.
Or if they did interview him,
there's no record of it.
They chose not to record what he said. Okay, Ms. Beer.
Yes, thank you, Chair. If you go to the bottom on the same page where it says para 10,
I have it.
it says during March 2015, the appointment of SSI reaches a boiling point with the sole shareholder of the RMC challenging the regularity of the appointment. What is the response by the committee?
No response.
Now, is this an...
Sorry, I missed that. Which one was that, Ms. Beer?
Para 10, Chair?
Para 10.
Yes, and the response by the committee is no response.
Oh, yes.
Yes.
So they chose not to investigate what this was about and whether this was factually true. Yeah, okay. I think we should take this tea adjournment.
Thank you, Chair.
We'll resume at 11:30. We adjourn.
All rise.
because that is the final safety net that failed us.
problem statement?
Not at all.
Does it deal with the track record of SSI?
No,
And does it deal with the beneficiation, other than telling us that the parties were given an opportunity to score? Does it deal with the factual statement that since the appointment of SSI, no beneficiation for the community has taken place?
no, not at all.
Well, this audit, risk and audit committee seems to really not have been interested in properly investigating the allegations. Here is a very serious allegation made here that SSI had no track record in the diamond industry prior to its appointment. They are supposed to have investigated that. And in response to that complaint, they are supposed to say, we have investigated this, we have found it to be true, or we have found it not to be true. They say nothing about it.
They just
and
ignore
yet it's
it.
such a critical issue. And on beneficiation, the allegation is, since the appointment of SSI, no beneficiation for the committee has taken place. Instead of dealing with that allegation, is that allegation true? They tell us what happened at the adjudication. I mean, that's so unsatisfactory. It's not the complaint. Yeah, okay, Ms. Beer.
Thank you. The next issue is in para 17, and this is the complaint. It is clear to us that SSI was created specifically for this tender. We do not know who the shareholders are of SSI and their relationship, if any, with any of the tender committee board members or the PSJV board members. We do not know if SSI complies with the PFMA. We do not know if SSI complies with the BBBEE legislation. We do not know if the other requirements that led to their conditional appointment have been met.
Correct.
And what is the response by the committee?
The appointment of SSI was done via round-robin resolution that was signed by all the board members. Mr. Karabi was not included as a signatory to the round-robin resolution as he no longer was a member of the PSJV joint board. The PSJV board from 27 January 2015 to 15 July 2015 consisted of 5 directors. All the directors of the PSJV board signed the resolution.
Again, do they respond to the very first allegation that it's clear to us that SSI was created specifically for this tender?
No,
Do they deal with who the shareholders are or their relationships?
no,
Do they deal with the compliance by SSI?
no,
Do they deal with any of the other requirements that led to their conditional appointment having been met or not?
no.
So again, the response is just filling up the space because it does not deal at all with the issues that are raised in the problem.
That is correct.
Now, I'll take you to the last one on that page. It says para 19.
I have it.
At the board meeting approving the appointment of SSI, our representative Willem Fries was misled by the rest of the board members and the CLO that Korabi had already approved the appointment of SSI and that it was a mere formality. They did not disclose to him that Bristow was involved. The board at the time was irregularly constituted as it required 2 independent directors from the RMC and a community director to constitute a quorum for the meeting. This was the requirement set by Alexco and RMC. What is the response?
We have received the affidavit from Mr. W. Fries, which we have enclosed for ease of reference under file reference 26, which indicates he was not misled to signing the resolution that approved the appointment of SSI.
Is there any indication that they referred that affidavit to Mr. Korabi to say, what do you say about Mr. Fries' affidavit that says he was not misled? Is there any indication that they did that on their report?
Not that I'm aware of.
So, on the face of their report, it looks like they got an affidavit from Mr. Fries saying, I was not misled, and that was enough for them.
Yeah,
And that's not investigating.
It seems to me that there was an original position which Mr. Fries had, which then changed and was confirmed by way of an affidavit.
Yes. Yes, Ms. Sabia.
And the last point that I want to refer you to in relation to this report is where it says para 21. Can you see that on page 265?
I do.
And the issue that is raised is, it is still not clear what the outcome of the due diligence was.
Correct.
And the response by the committee?
The outcome of the due diligence was forwarded to the board on 29 January 2015. The RMC representatives were represented throughout the tender process and was well aware of the outcome of the due diligence.
Does this tell us what was the outcome of the due diligence?
No.
So all it says is you should know it. In effect, in a nutshell, it says the RMC representatives were represented throughout, and the outcome was forwarded to the board.
That is correct. And that's a false statement because we already know from the evidence of Craig Matthews or the correspondence of Craig Matthews in the Samela judgment that is a false statement.
And then we get to the conclusion. What is the conclusion that is drawn, that just that paragraph under the heading conclusion?
Based on the affidavit and collaborative evidence reviewed by the committee, we could not find any fundamental breach of procurement procedures adopted by PSJV other than, I think it's a typing error, it says manner of housekeeping that we have alerted the management of the PSJV to correct.
Yes. So they did not find any wrongdoing.
That is
Their
correct.
conclusion is everything was above board.
Correct.
Thank you. Now I take you to a new topic.
Well,
Yes.
that report, who is it signed by, Mr. Grayson?
I do not have a signed version.
Not signed, but who is reflected as
It's
the
Ms.
author of the report?
Ms. M. Lehobai, Chairperson of the Audit and Risk Committee.
Yes. And according to what she has written there, she is a chartered accountant.
That is correct.
We need to have, if you do not already have, we need to have an affidavit from her explaining this report. And all attempts must be made for her to be called to give evidence and be questioned about this report.
Noted, Chair.
Let's continue.
Thank you, Chair. Mr. Craythorne, I'm taking you to your affidavit on page 54. This is a new topic.
Page 54.
Yes.
Yep, I have it before me.
Okay, you see the heading there, almost at the bottom. the proposed diversification of Alexco into the coal industry.
Correct, I have it before me.
Now, you say in your affidavit that with the appointment of Gigaba as Minister of Public Enterprises in late 2010, a process of twin state capture began, while at the same time expropriating Alexco's diamond assets, initially through SSI and later through Transhex, a group with links to regiments set about capturing Alexco itself in pursuit of coal supply contracts to be concluded by Gupta proxies at Eskom.
Correct.
Where did you get all of this? How did you reach this conclusion?
I reached this conclusion as a consequence of having consumed quite a fair amount of evidence over time. The apex document in regard to this would be what is referred to as the Quesco plan, which is a document that sets out a collaboration amongst a vast array of political and business elites in South Africa to use Alexco's marine mining assets as the core component of a total monopolization of the entire West Coast diamond mining industry, extending even across the border into Namibia.
Mr. Craythorne, if I can refer you to bundle 4B. Page 1203. 1203. Is this the document you are referring to?
That is correct.
So the document that is titled Quesco, Corporate Advisory, West Coast Diamond Consolidation, that's the document.
That is correct.
Can you briefly tell us who are the parties to this document and what it tells us?
The parties to this document are Transhex, a corporate advisory by the name of Quesco, the De Beers, the Department of Public Enterprises, the Richtersveld Mining Company, and the PSJV.
And this appears on page 1207. Is that correct? And when I say is that correct, I mean, is it really correct? You can correct me if I'm not correct.
That is correct. This is a portion of the document focusing on the stakeholder needs analysis that was conducted by the participants in this project.
And how did you get hold of this document?
It was given to me by a hitchhiker.
Sorry?
It was given to me by a hitchhiker.
A hitchhiker, someone you gave a lift to, gave you this document.
That's correct.
What did he or she say you must do with the document?
Well, I was driving from Alexander Bay to Port Nolloth. I picked up a gentleman from the Richtersveld who was hitchhiking, and whom I happen to know actually. And he asked me how I was looking forward to the new owners of Alexcore. And I said to him, well, what are you talking about? And he started telling me about a plan that would result in what we are looking at here in this document. I found it quite fantastical. And I took it with quite a pinch of salt, but he persisted, and when we got to Port Nolloth, he said to me, well, just park at this address, and I will go and fetch you a copy of the document. And that is how I came to have possession of this document. It was given to me by a gentleman who I picked up hitchhiking. And this is a very important document in connecting the dots.
So what was the importance of this document to you?
The importance of this document to me is that, first of all, the stakeholder analysis excludes one of the most important stakeholder groups in the region and who depend upon Alexcore's success as an SOE, which is the group of people I represent as a member of the EAC, and that is the diamond diving community, because it is the diamond diving community that have contributed more to the operational profits of Alexcore and the PSJV than any other segment of the business. And included in the stakeholder analysis is a collection of elite government and business and community representatives that set out to capture Alexcore's marine mining assets.
In fact, you say in paragraph 241 of your affidavit in bundle 4A on page 55.
241?
Page 55, paragraph 241.
Okay, could you repeat the paragraph number for me, please?
The page is 55.
Yes.
The paragraph is 241.
I have it before me.
Yes. You in fact say there that as it turns out, yes, continue.
As it turns out, while I was trying to persuade the Alexcore board to review the SSI contract and to report on the true value of Alexcore's marine diamond assets, unbeknown to me, Transex, Quesco, Causa, and Carstens had devised a plan to persuade Alexcore to dispose of its diamond assets in the region and to diversify into coal.
Mm. And you say what this in fact envisaged was the creation of a platform in order to take management control of Alexcore's marine diamond operations, construct a false narrative about the future mining potential of the marine mining rights by telling all stakeholders that the diamonds will be mined out within 5 to 10 years, while simultaneously stripping the assets and running the town and mine infrastructure into the ground, and to purchase Alexcore's marine diamond operations when government has lost hope in any future success and take over the 51% stake in the PSJV.
That is correct.
Mm. Now, why do you say it would be a false narrative to indicate that the diamonds would be mined out within 5 to 10 years?
Well, while it is a well-known geological fact that Alexcore possesses the most stunning deposit of gem diamonds that have ever existed on the planet, it was the PSJV management team under the leadership of Mr. Carstens were telling the portfolio committees, both the NCOP and the portfolio committees, that Alexcore if I can quote his exact words, in one particular sitting that I attended, he stated that in 5 to 10 years there will be no more mining, which is extremely misleading because the actual mining of the Orange River Delta's Diamond Plaza has only just begun. The last 100 years has only really mined probably less than 10% of the overall deposit. The balance of the deposit remains in the ocean, covered by sediment, which poses geotechnical challenges that have preserved it and which now is set to be mined due to the evolution of technological advances over the past 10 years. And confirmation of that is seen clearly in the great success that the Namibian government and De Beers are having on the northern, just on the northern side of the deposit, because the single maritime boundary between Namibia and South Africa passes right through the middle of this deposit. On the northern side of the border, you have an extremely successful marine diamond mining industry that is spending money hand over fist. The latest vessel is currently under construction. Investments in excess of a billion rand, to produce vessels, while they are producing 1,500 million carats a year and more. We are struggling to produce 55,000 carats a year on our side. So it's the same deposit, but with two very, very different, it's a tale of two cities or a tale of two deposits. Same deposit, two approaches.
And of course, the diamonds don't know where the boundary lines are.
That is correct, and I would argue that the South African side of the boundary is the most valuable because of the Pallier River system. And look, those are geological issues I won't go into now, but that is my personal view, is that the diamonds that are in Namibia have actually been sampled by the current that flows south-north from actually South African deposits. So the major eye of this whole deposit is lying in South African waters. And that's why there's a major boundary dispute going on at the moment between South Africa and Namibia.
And of course, if you look at the Quesco plan and the persons mentioned there or the entities mentioned there, why would they be interested in buying Alexco if there was nothing left to mine?
It's just incredibly arrogant or audacious, in my view, because it's just shockingly audacious, in my view, that people could think they can actually pull off something like this.
Now, you say that this plan was given traction as Gigaba had repurposed the Alexco board in order to implement its emerging black coal miner exit strategy.
That's correct.
What is this strategy?
The strategy was to pivot Alexco away from the mining of diamonds, which seemed to be very much a sunset industry. And the narrative that has been peddled to the government as the shareholder representative for the people of South Africa in regard to the diamond deposits in the sea have been downplayed very much. So the strategy that was embarked upon after 2010, when Minister Gigaba was appointed the Minister of Public Enterprises, has got a level of rationality to it, but it was done without having full cognizance of what Alexco would lose as a result of such a disastrous strategy. Because in effect, what he would be doing, either knowingly or unknowingly, he would be pivoting a state-owned company away from the most important diamond rights in the world today towards a coal strategy in an era where we're moving from fossil fuels to renewables, and it just seemed like a tragic strategic blunder to me.
And if I can take you to page, to bundle 4B. And page.
Must I keep bundle 4B here for the rest of the hearing? Are you going to be referring to it further?
I will ask the chair to keep it, but the chair must please forgive me if I don't refer him to it after this.
So you are not sure?
Yes, Chair.
What page?
It's page 1106. And my apologies for the way the page is printed, Chair. It will be corrected.
Yes.
Thank you. Are you there, Mr. Creighton?
Not quite. 107. I do have it before me.
What is that document that starts on that page?
It's a document from the PMG Parliamentary Monitoring Group's archives, and the heading is Eskom Inquiry, Malusi Gigaba, Public Enterprises, 13 March 2018.
Yes. Now, if you turn the page to page 1107.
I have it.
Do you confirm that this is not the whole document, but just certain extracts from the document?
That's correct.
So this is page 3 of 32 is what is marked at the bottom on the right-hand side.
I see that? Yeah.
Okay. Now, can you read the highlighted part at the top of the document?
Minister Gigaba.
And that means he is the one that is speaking, am I correct?
Correct. Do I read the entire paragraph or just the highlighted
Yes,
section?
you can read the entire paragraph.
The discussions with regard to specific coal contracts of Eskom, I did not involve myself in those. I hold myself in a broader policy discussion with Eskom. This was predicated on what we were drafting as the emerging miner strategy, which we started engaging on around 2012 when we were saying by 2018 we would like the 50% plus one of Eskom's coal to be provided by black coal miners. I therefore had that discussion with Eskom, and we had several meetings with the board of Eskom. The strategy itself was being drafted by Eskom and spearheaded by the Eskom board, including the executive directors. We had 2 consultative sessions with emerging coal miners at which we had specific discussions around these issues.
Yes, and then you've got Advocate Vanara saying there appears to be an outcry even today from black emerging miners, and this was in March 2018, to access the business. What programs did you put in place at the time, or see to it that the board addresses the transformation issues? You can read the response up to the end of the highlighted section.
Minister Gigaba, the emerging miner strategy eventually was not implemented. I think one of the things we were trying to do at the time was that we implemented a business case where Alex Gore would diversify from diamond mining solely to also become a coal mine and supplier to Eskom, with Alexco as the basis to spearhead this emerging miner strategy and bring on board many other emerging miners. The emerging miner strategy was the biggest plan we were working on and would have resulted by now in billions of rands being managed by black coal miners.
Yes, and on the next page, 1108,
Yep.
read the highlighted portion, indicating who's saying it.
Mr. Gigaba speaking, I was spearheading the establishment of a policy intervention, the emerging miner strategy, which would have resulted in the ending of those evergreen contracts.
And then if you turn the page to 1109, Minister Gigaba again unpacks the details of the emerging miners strategy, and he says one of the objectives was that by 2018-2019, 50% plus one of coal supply contracts to Eskom must be provided by black emerging miners in South Africa. We agreed with them on the approach to take, and they were supportive of the policy proposal we were creating. That is when we began the discussions between Alexco and Eskom to diversify Alexco's asset base to involve not only diamond mining, but also coal mining, so that we use Alexco to leverage the involvement of black miners in the coal supply program. Now, do you accept the statement?
It's not entirely true because it creates the perception that the intention was to leave Alexco in diamonds and extend its focus into coal, whereas the briefings that Alexco gave to the portfolio committees in Parliament made it very clear that Alexco's strategy was to exit diamonds in the West Coast and pivot to coal.
Yes. Now, if I take you a few pages back in the same bundle to page 1101. (1101).
I have it for me.
What is this document that we are looking at?
It's a media address statement by Mr. Malusi Gigaba on the 7th of September 2012.
Yes. So this was at the AGM of Alexco.
That's correct.
Yes. Now, if you read on page 1101, the highlighted portion, the last paragraph of the highlighted portion.
That's the very last paragraph.
Yes.
In this regard, I've appointed Mr. Rafik Bachus as chairperson of the new board, who will be assisted by Ms. Gillian Noglanda Jayeni, Dr. Yvonne Nono Maatsoa Matabani, Ms. Lukiswa Ntlangula, and Mr. Mohammed Baba. I have given the new board the responsibility to fill the vacancies of CEO and CFO forthwith by no later than 3 months.
Yes. And the paragraph before that?
I have assessed the needs of the company and the capacity of the board to be able to execute its fiduciary duties over the state-owned company. Our annual review of the board has necessitated that we rotate the board and include new skills sets and expertise to give impetus to the new strategic direction that the shareholder wants Alexco to take.
Yes. If I can just stop and mention a side issue, I'm informed that I'm pronouncing the surname of Mr. Rafik wrong, and it's not Bachas, and it's Begas.
I beg your pardon,
So-
that's my fault.
Yes, I know it's your fault, Mr. Crathon, because I asked you how to pronounce it, but yes. So moving forward, I'll pronounce it as Vegas.
I concede.
Yes. On the next page, 1102. We see the line that starts during the past financial year. Can you read that for me, Mr. Crathon? It's the first line.
Of 1102.
Yes. The second
Okay,
sentence.
the shareholder has retained.
The second sentence of that line. During the past financial year.
Okay, I have it. During the past financial year, Alexcor has managed, to a large extent, to fulfill the developmental objectives of government by ploughing back to the community in which its operations are based. This is at the core of how the mining industry can contribute positively to the development agenda of the state, by ensuring that the benefits of the mining operations are accrued to the communities in which they operate. The Richtersveld PSJV can provide the country with a best practice on how the mining industry can become good corporate citizens by investing in human settlement for long-term economic and social stability.
Yes. So as at this date, the minister is talking about the developmental objectives of government. He's talking about ploughing back to the community in which the operations are based. Now, how do you contrast this with the new strategy that was then being talked about later?
Well, it was completely at odds because the diversion, because my understanding that although there would be a PSJV executive team and a joint board to oversee the activities of the PSJV executive team, Alexcor still had a very real responsibility to ensure and provide oversight to make sure that the deed of settlement and the unanimous resolution were successful projects. And by diverting attention to coal mining in Mpumalanga and in Gauteng, the board was completely redirected away from what was going on in Alexander Bay. And in addition to that, a large amount of funding that should have been utilized for rebuilding the mine and town infrastructure after the long internecine court battles to enable Alexcor to recover from the court battle and become a successful stated enterprise, because all of the elements were there. You had the human capital, you had the resources, you had every possible conceivable comparative advantage that you would want. And in spite of that, we ended up with the disaster that we have. And that is in large part to do with Alexcor being redirected away from the activities in Alexander Bay, and also the redirecting of crucial funding, which had been allocated to Alexander Bay by way of the medium-term budget, and other funding. A lot of the interest that accrued on those funds was all utilized for pursuing coal ambitions, which had nothing to do with us in Alexander Bay, and we were in effect funding those activities.
In fact, if I can take you back to bundle 4A that has your affidavit, if I can take you to page 62.
Ms. Bia,
Yes, Chair.
we have just reached 2 hours that I gave you. How are you doing?
Chair, we will be done before the lunch adjournment.
You are asking for more time.
Yes, Chair, I'm asking for more time. I was careful not to promise that I would keep to it, but rather to indicate that I would try.
Well, you were not asked to promise. You were given a deadline.
Yes, Chair.
Okay, I'll let you continue until 1.
Thank you, Chair.
Let us see. Just try to focus on the important features of
Yes.
Mr. Creighton's evidence.
Yes, thank you, Chair.
Okay, all right, continue.
Thank you. Page 62 of bundle 4A.
I have it before me.
Yes. In paragraphs 280 to 282, you express this frustration of the money that was being spent in pursuit of the emerging black coal miner exit strategy, and that it was in fact being generated by the marine miners of Alexander Bay and should have been applied to its maintenance, but instead about 40 million rand per year since 2012 had been diverted to fund corporate headquarters in Joburg and to pay consultants working on this exit strategy.
That's correct.
Now you say that the concealment on page 63, that the concealment, paragraph 285, the concealment of the true value of the marine diamond assets Alex Corp possesses and the misrepresentation of the
I'm
estimated
sorry,
life.
what page are you reading from now?
63, Chair, and paragraph 285.
Okay.
Yes. It says the concealment of the true value of the marine diamond assets Alex Corp possesses and the misrepresentation of the estimated life of its diamond mining ventures in the region has provided the new board with a rationale for exiting its diamond mining business and diversifying into coal. However, should it sell off its marine mining business under the current manufactured climate, it would seriously under-recover for its business. It would also mean the individual miners would be forced to liquidate their mining operations at a substantial loss.
That's correct.
Yes. Now, you've indicated that there was instead a lot more coal that was yet to be mined. And you say that Mr. Carstens misled Parliament in page 62 of your statement.
That's correct.
And what did he say on the 22nd of November?
Which
On
paragraph?
paragraph 282 at the bottom.
282. Since 2012, approximately 40 million rand per year has been diverted to fund the corporate headquarters in Johannesburg and to pay consultants working on Alex Corp's exit strategy. To justify this, Carstens has continued to undermine Alexander Bay's future diamond mining prospects. In Parliament on 22 November 2017, Carstens stated, "In 10 years' time or 5 years' time, there is not going to be a mine anymore."
And yet you say there'd been a lot of money that had been spent on this exit strategy. In paragraph 284, on page 63, you state the amount that had been spent by financial year 2016 as having exceeded 175 million rand.
Correct.
And this is money that you say could have comfortably recapitalized the entire Alex Corp diamond fleet with new technology and semi-mechanized mining vessels capable of mining through sand overburden. Had this money been properly spent, this could have ensured that Alexander Bay could once again become a world-class diamond production center.
Correct.
Yes. So the money was available,
Indeed.
but there was a decision to not plow it where it's needed.
Correct.
Yes. And according to you, or your understanding, sorry, Chair, if you can just bear with me. Sorry, Chair, I've lost my train of thought, so I'll move away from that point. Now, what was your biggest problem with diversification?
The biggest problem was the fact that it would ultimately lead to Alexco exiting its crown jewels.
And what would be the consequence of that?
Well, the consequences of that would be that you would have a total and absolute monopolization of the entire West Coast diamond mining industry, both on land, which is brownfields, and in the ocean, which is the next 100 years of global production will be coming out of the sea off the coast of Namaqualand.
Yes. Monopolization by whom, at whose expense?
The monopolization of the interests that are mapped out in the Quesco plan, and the losers would be the South African public, and most importantly, the people of Richtersveld and Namaqualand, because there would be no participatory development. It would all just be the same old brute force. This is what we offer you, take it or leave it type of scenario. The money would be flown out and siphoned out of Namaqualand, as it has been done for the past 100 years. The only difference would be that the environmental damage that we sit with on land would now be ending up in the sea as well. And there are very serious signs of that already. Enormous amount of environmental destruction has already taken place.
How you put it in paragraph 286 is, please just read that paragraph.
The dynamics of a primary board and executive team that is conflicted by a Gupta Gigaba coal agenda, and a PSJV board and executive team that is conflicted by a Transhex Quesco diamond agenda, has resulted in the decimation of the local economy, dilapidated critical infrastructure, and a loss of social cohesion. It has also deprived Alexco and the Richtersveld community of its share in what could and should be a lucrative diamond industry. This has served to dispossess the people of Namaqualand and South African taxpayers of a mineral asset of immense value and strategic importance.
Yes. Now tell us about the involvement of Begas, Kellerman, Carstens, and Koza in the Quesco plan. What role did they play, each of them?
One of the major problems with the Quesco document is that it makes provision for a shareholding, if I recall correct, of 9% to be ring-fenced for the PSJV management, which has hopelessly conflicted anybody that has at ever time been involved in the operational management of the PSJV's operations, having been promised a share of the final consolidated enterprise that was proposed in the Quesco document, places all of those individuals in a position of conflict. It's almost as if they had decided that the Quesco plan was a fait accompli. You can manage this enterprise into the ground. The more you manage it into the ground, in fact, the better, because it simply means that government will have greater levels of fatigue, and the pursuers of these assets will have to pay less.
Yes. And in addition to that, can you explain to us the role of each person in the decision-making process?
Well, while former Minister Gigaba claims in his testimony before Parliament in the Eskom inquiry that the idea was to keep Alex Gore in diamonds and just redirect Alex Gore into coal, the parliamentary briefings that were given by the Alex Gore board under the chairmanship of Mr. Rafiq Begas made it very clear that Alex Gore was exiting diamonds, and that the best thing for the people of Namakoland and Alexander van Richtersveld would be for Transhex and De Beers to take over the operations. And that documentation I've provided in annexures.
And as we've already said, what would be the point of anyone buying Alex Gore if there was nothing left to mine?
Correct.
Now, if I can, you say in your statement, in your affidavit, that you brought these concerns to Parliament.
I did.
Yes. And you refer to a date where you raised this issue as November 2016.
That is the first time at which I publicly raised concerns over state capture, although that was not, state capture hadn't at that point really become centered around the Guptas. But it had certainly been around for as long as South Africa's been on the map. So,
well, 2016 is when Mr. Jonas went public about the meeting that he had had at the Gupta house, isn't it?
okay,
I thought he went public in March 2016 about a meeting that had happened in October 2015. He went public in March 2016.
Thank you, Chair. Look, if I'd been a little bit better informed, I might have been more concerned about, at that stage, about I only became more aware of the Gupta links.
But of course, not only that Mr. Jonas went public in March 2016 about allegations of an offer of the job of Minister of Finance and money that he said was offered to him. But 3 years earlier, in 2013, there had been the Gupta landing at Waterkloof, which had captured the attention of the whole country. So it can't be true that in 2016 the country hadn't heard about allegations of state capture by the Guptas.
Correct, Chairman. I will agree with that, but I don't think the country was taking it seriously enough.
And
yes, Ms. Beer.
thank you. In effect, what you are saying is you at that time were not concerned about the state capture by the Guptas.
Well, I was concerned, not in a sort of a general way, because I had witnessed what had transpired with the Imperial Crown Trading affair and the iron ore assets that they tried to capture. And what concerned us as the EAC is that at that particular time, we were trying to reach out to the Department of Mineral Resources regarding issues of concentration in our industry and monopolization. And while we had immense difficulty in that, the Guptas had their situation fought all the way to the Constitutional Court. So you had the department ignoring our pleas for attention on our industry, while at the same time spending hundreds of millions of rands in taxpayers' money trying to defend the Gupta's hijacking of iron ore assets through Imperial Crown Trading. So that irked us as the EAC a fair amount.
And you referred us to the presentation and to the Portfolio Committee on Public Enterprises that appears in bundle 4B on page 1042. 1042, 1042.
I have it in front of me.
Yes. Now you say this is when you raise these matters.
Correct.
Matters of state capture. Now, what was the response by Alex Corp?
Well, as I attended this portfolio committee briefing, I listened to the board confirming its continued insistence of pivoting away from diamonds towards coal, and even more investing funding in a diamond beneficiation project. And that just amplified my concerns. And subsequent to the portfolio briefing, I had a chat with Zukiso Ntlangula, and I said to her, look,
Who is Zukiso Ntlangula?
she stood in for the chair lady, Hansi Matseka, because she had a family emergency. So Zukiso Ntlangula, who was a board member, was the stand-in chairperson for the duration of the briefing to Parliament. So subsequent to that encounter with Ms. Ntlangula in Parliament, I approached her and I said to her, look, you really need to reconsider the strategic direction that you are embarking upon. And I said that I had written a extensive document outlining what the true potential was for Alexander Bay as a marine diamond mining center going forward, which she had not been given. I had given the report to Mr. Carstens earlier that year, I think in April, but he had not distributed it to the board of Alexcor because that would have not supported the Quesco plan at all, because it was very convenient for the Quesco team to have the Alexcor coal team stay focused on coal.
Now, as a result of your interaction with Zugiswa on that day, what else did you do?
I then undertook to provide her with further information by way of an email. I informed both Zukiswa Ntlangula and Honorable Zukiswa Ranto, who I addressed my correspondence to. And I included also Ms. Terry Stander from the DA as well, who was also present at that meeting that I attended. And I said, look, this is what I think is going on. You are dealing with a situation where there are strategic blunders currently unfolding, which you need to address. And I'm prepared to author a document, put a document together for you, but I will need some assistance. And they were very pleased to hear this. And a month later, I got called into a meeting by Mr. Mervyn Carstens and Ms. Reagan Phillips, who, this was just before the mine closed, the day before the mine closed in December 2016, and they were extremely irate. They confronted me with the fact that I had suggested to Parliament that Alex Gore had been captured by Transex, and I said to Mervyn, well, I'm afraid, Mervyn, I feel you've betrayed us. And they felt it was outrageous that I was interfering in strategic matters, and I felt as a serious investor. My wife and I have invested everything into our business in Alexander Bay, and for us to have that investment be jeopardized by ill-informed and bad decisions, in my view, was unacceptable, and I was not prepared to keep quiet about it.
Now, you say that you, on the 30th of November, on page 52 of your affidavit, in bundle 4A.
Page 52.
Yes.
I have it for me.
Okay. In paragraph 230, you say that the Equitable Access Campaign traveled to Cape Town to hand over a warning about the serious governance problems and state capture at Alex Corps to numerous portfolio committees.
That is correct.
Yes. What did you tell them?
Well, my fellow ESC colleague, Mr. George Nicolai, who is in the gallery today, took a document outlining the situation as Alex Gore. At Alex Gore, as I saw it as someone who was very deep inside the affairs of both Alex Gore and the PSJV. And he drove down to Cape Town. The idea was to print multiple copies, but it would have been too expensive for us. So Mr. Nicolai then made electronic copies on thumb drives and went door to door in Parliament to numerous portfolio committees and handed thumb drives of the document which I authored, setting out the state of capture in regard to Alex Gore.
And was there a response?
There was a limited response, but nothing concrete emerged out of our interactions with Parliament.
Do you confirm that this was not the first time you reported to Parliament?
I confirm that.
And in fact, you had previously written to Minister Brown,
Correct.
and the result had been the report that we referred to earlier, where there was an investigation that came back with no real findings.
Actually, okay, if you're referring to the ARC report was a consequence of the complaint from Mr. Karabi. What flowed out of my complaint to Minister Brown was a letter of response thanking me. She then made contact with the board of Alex Gore, and as a consequence of that, I was invited to attend a board meeting in Kimberley, and I then traveled down to Cape Town, flew up to Kimberley to attend that board meeting. And at that board meeting, I raised some of my concerns in relation to the poor diamond pricing, the strategic realignments that were unfolding, and the lack of transparency and public accountability.
Yes. Chair, if the chair can give me 1 minute, just to bear with me for 1 minute. Yes, thank you, Chair. In fact, I'm not sure which bundle I last referred you to. So in bundle 4B,
Okay.
on page 1127.
Just repeat the page.
1127, 1127. This is a letter that you sent to Kim Davids. Tell us about that.
This is a letter that I addressed to Ms. Davis on the 9th of March 2017 after attending when the ESC as an organization concerned with the rights of the small-scale marine miners in Namaqualand, we became convinced, and there was overwhelming evidence to the effect that there was major corporate realignments that were taking place without us being consulted as a stakeholder. It's become clear that to us as an organization that the level of stakeholder materiality for the marine miners is zero. And we then tried to muster support from our members to confront what the revelations that were being made by accident, by way of the Quesco document, and formally in Parliament by way of the briefings to Parliament concerning the exit strategy and other very, very serious decisions, in the hope to try and raise our level of stakeholder materiality. Immediately after that, we were sent quite a harsh letter from Ms. Matseka denying that there was any corporate plans to exit Diamonds or anything of that nature. So when it seemed to me that it was pointless trying to raise the EAC's concerns with the Alexcore board in relation to these major realignments, that I'd have to reach out to the minister. And the purpose of contacting Ms. Davids was to reach out to the minister in this regard and try and get her intervention.
And in fact, she responded to your letter on the response appears on page 1145 of the same bundle.
I have it before me.
Yes, is that the response that you got from the minister?
That's correct.
And it, in effect, in paragraph, in the third paragraph, says the department will convey the report which you had prepared to the Department of Mineral Resources for review and consideration. And furthermore, the department notes the results of the survey undertaken to assess the level of satisfaction amongst the Alexcore pooling and sharing joint venture contractors. I recommend that you approach the board of Alexcore and Alexcore PSJV to address your concerns. Had you not already done this?
Pardon?
Had you not already done that?
Yes.
But
there were two letters written to Minister Brown, and I'm not sure of the sequencing. So I'm not sure if this was the second or first one. But I think this is what led to the visit to. I beg your pardon. This was the response I got from Minister Brown. The second time I think I reached out to her was when we were being sued by Weber Wenzel.
yes.
Or thereabouts, or when we were being threatened to say, look, we know better off, after having gone and, tried to meet the board and, I beg your pardon, we are now, as an organization and as a group of contractors and as an important segment of the Alexcore operations, we are, the situation is deteriorating. So the first attempt, reaching out to Minister Brown, was successful because it led to a meeting taking place, or a board meeting, and me being invited to attend the board meeting in Kimberley. When I tried to raise the issue around the Quesco document, Chairperson Hansi Matseka refused to discuss it and directed it to operations on the mine, and the lack of transparency in relation to the diamond prices and the deteriorating labor relations between the contractors and the PSJV management.
And the minutes of that meeting appear on page 1146 to 1148. Is that correct?
That's correct.
Yes. If the chair can give me 1 second to check with my teammate. Thank you, Chair. Chair, from our side, that is the evidence that we would like to present in this forum. But I would like to invite Mr. Craythorne if there's anything that is burning him that he feels I may have left out.
Yes, is there something, Mr. Craythorne, that is contained in your affidavit or annexures that you think is very important that you haven't been given a chance to cover in your oral evidence?
Thank you very much, Chairperson. Through this whole period of rampant state capture, I've had many issues and things that have disturbed me, but of all of the phenomena that have disturbed me the most, the failure of Parliament to protect us is for me the most disturbing, because we approached Parliament over and over so many times, going back to 2010 even. And when I read in PMG summaries, statements made in Parliament by, for instance, Honourable Cathy Lablack-Skagny from the NCOP, putting on record that the NCOP was told to stay away from Alex Gore. I want to know who told Cathy Lablack-Skagny to stay away from Alex Gore. Because that, I think, is just the tip of the iceberg. And I think if Parliament had done its job, I would not be sitting here and extending my time.
Well, that's something very important, Mr. Craythorne. I think we are going to adjourn for lunch, but I'm very interested in that aspect, as I have indicated before. I would like, if it's possible, when we come back at 2, I'm going to hear about Eskom's witness for today. I'll hear from the evidence leader who was to lead that evidence and about the rest of the week. But when we come back, before I hear what they have to say, that is that work stream, I would like you to, Ms. Sibia,
Yes.
to lead him on those specific issue, on that specific issue,
Yes.
with special reference to the dates of his communication or their communication to Parliament, what it was about, when was it, was there a response? If there was, what was the response? Because it's quite important that the Commission establishes what Parliament was busy doing as some of these things were happening in state-owned entities, particularly when these matters were brought to their attention. Did they do their job? If they didn't do their job, why did they not do their job? What was going on? That is quite important. So we'll adjourn. But you confirm that that's the part that you wanted to bring to my attention.
Indeed.
Yes.
Chairperson.
Okay, all right. We will take the lunch adjournment. We come back at 2. Then Ms. Bia will deal with that. But obviously, because you know your documentation much better than us, you will also have a look and be able to say to her, here is the relevant correspondence. That's the date, that's the page, and this is what the response was, or there was no response. I want that I'm very interested in that.
Thank you very much.
Okay. Okay, Ms. Bia, so we'll take the lunch adjournment. We'll take the lunch adjournment now and resume at 2. We adjourn.
All rise.
simply a special affidavit that deals with this particular issue and refers to correspondence, and then the copies of the correspondence can be attached, dealing with it very systematically to say, on this date, this is what we wrote to Parliament about. This is what they said in response, or they said nothing.
Yes.
Then on such and such a date, we wrote about the same thing or about something else. Again, there was no response, or this is the response we gave. Such and such a date, we went there. We met with so-and-so, we raised our issues, but nothing happened after that, or this is what we were promised, but nothing came of it. That kind of systematic narration of the issues. Okay, no, that's fine. Then we don't need to deal with it today.
Yes.
And that affidavit will be finished, and then a decision can be taken at that stage whether it would be necessary for Mr. Creighton to come back and give oral evidence about it. It may be that the affidavit will be enough, and that it can then be given to the relevant people in Parliament to say, respond to this affidavit, to these allegations, and then we take it from there.
Thank you.
Okay, all right.
Perfect.
Okay, no, that's all right. Then it means I should excuse you now, Mr. Creighton. Thank you very much for having come to give evidence, and if necessary, we'll ask you to come back, but if possible, if at all possible, we'll try and avoid that. But if necessary, we will ask you to come back. But thank you very much. You are now excused. Thank you.
Mr. Chair. Mr. Chair.
Where is the... Oh, I'm sorry.
Sorry.
Mr. Bam, I'm sorry. I saw you in the morning, but I think I didn't see you now. Yes.
In this commission, I always try to keep out of the light. Mr. Chair, can I just briefly state that on behalf of the State Diamond Trader, you may be familiar with the affidavit that we filed on behalf by Mr. Munguni on behalf of the SDP.
Okay, no, I haven't seen it.
But it doesn't really matter.
Yeah.
We've listened over a day and a half carefully to Mr. Creighton's evidence. We've considered the paragraphs we've been referred to in the notice, and we've come to the conclusion that there's no need for the SDP to trouble this commission with any cross-examination. And I thought I'd just place that on record. With that, may I ask if we may be excused?
Yes, no, thank you very much, Mr. Bam. You are excused.
I'm grateful. Thank you.
I always say that the advantage of having experienced counsel representing parties is because experienced counsel knows the issues that are important, and they won't want to just cross-examine for the sake of cross-examining.
I'm glad you say so. My wife doesn't always agree. Thank you, Mr. Chair.
You are excused. Thank you, Mr. Bam. Is the Eskom work stream team here? Mr. Selega is supposed to be here.
Doesn't appear so at the moment, but the junior is present.
Solitly, do you know anything?
Chair, in addition, they need a short adjournment because the witness will be testifying via media. So,
Well, the evidence leader must be here first. Is his junior here?
yes.
Yeah, please come forward. Tell me what's happening. Yes, good afternoon. Yes, switch on the mic.
So I must apologize for myself. I'm not entirely sure why he's not present. We had made arrangements to meet at the venue by 1, so I did send him a message. I assume he's driving. But Chair, may we ask for a short adjournment so that I could call him telephonically to find out where his whereabouts, as well as the fact it might give us a short opportunity just to link up with the witness who's not going to be present.
Yeah. Is that Ms. Nteta?
Yes, Dr. Ayanda Nteta.
Yes. I assume that Rule 33 notices were served quite a long time ago with regard to her evidence because she was going to testify some weeks ago.
Indeed so. She was going to testify last year, December, and then there was, it was in the last week, so.
Yeah, okay, all right. No, that's fine. Then we are going to adjourn, but I need to talk to Mr. Beer before we adjourn. Thank you.
Thank you.
Mr. Beer, do you want to come back to the podium? In terms of the way forward with regard to Expropriating, I know that you have a commitment that makes you unavailable from a certain date.
Yes, Chair.
Is it from the 18th?
Yes, it's from Monday
Up to when?
until the 22nd, 21st of February.
Yes. So you would only be available after that to finish whatever needs to be finished in regard to Expropriating?
Yes, Chair, I would not be, it would not be proper for me to be engaged.
No, I accept that you
Yes.
won't be able to.
Yes.
I was just making sure that you will be available after.
Oh.
Okay, so the witnesses that you still have are Mr. Bishop,
And Mr. Decker,
then Mr. Decker,
and then the implicated parties.
You need to have Mr. Customs,
Mr. Bakers,
Koraba, and Mr. Bakas.
yes,
Certainly, we need to have their affidavits.
yes,
And then we can see where there might be no need for oral evidence and where there might be need, but we certainly need to have all of those in as soon as possible. I would like that all attempts be made to make sure that by end of January, all those affidavits are in. And obviously, when they come in, copies need to be given to people like Mr. Creighton and maybe Mr. Bishop and whoever whose evidence might be disputed by those people
Yes.
in certain respects, so that we reach a point where we say all affidavits are in and everybody has commented on everybody's versions that relate to
Chair.
them. And then we can take it from there.
Yes, Chair, thank you very much. We will attend to that.
Yeah. Okay. I'm going to hear in terms of the rest of the week as far as the work stream, the Eskom work stream is concerned. It may well be that there might be days this week when they are not going to be able to use. Now, if that were to happen, subject to your own commitments for this week, it might be something to think about whether Mr. Peter Bishop could be brought in when a day becomes available or half a day to come in and give his evidence. But if your situation doesn't permit, because that was not in the original plan, that's fine, I'll understand. Then Mr. Bishop can give his evidence after you have become available.
Thank you, Chair. It would not be
It
possible.
would not be possible. Okay, no, that's all right. I'm going to take a 10 minutes adjournment to enable the Eskom Weststream to get ready. We adjourn.
All rise.
Dr. O? Wait, anyone? Can you please pick up? Unmute the Tumza. To me? Unmute. Thank you. Dr. O? Wade? Anyone can hear me? Hello?
Yes, we can hear you.
Thank you so much. Thank you, Dr. O. Thank you. Dr. Nteta?
Yeah,
Thank you. Tumza? Good afternoon, Dr. Nteta.
good afternoon.
needs to be moved a bit. I don't think it is where you usually have the screen. Yes, but can you move her screen a bit? Or I think normally it's a little towards that side, yeah. Is it in the same position? Or the room is different? If you move the screen, what will happen? If you move it towards this, yes, like that, it shouldn't affect her. Okay, I think that's much better, yeah. Okay, all right. Okay, you may continue.
Thank you, Mr. Chair. Mr. Chair, I must apologize. Before you walked in, we actually was just, I'm not sure if the witness has the links of the files because I need to take her through her statement.
Yes, you can check with her.
Dr. Nteta, an email link was sent to you shortly. Have you had a chance to open it?
I don't know if your voice is naturally soft or low, or whether you should speak closer to the mic, or you should raise your voice. It's, try your best.
I will indeed.
Okay.
Dr. Nteta?
Okay, I'm currently opening my emails.
Thank you. There should be two links that would have been sent to you. The first one would contain, it should say Exhibit Bundle 14, or it will read Exhibit U28.
Okay, I have not received either. The last email I've received was the meeting request.
Okay.
I'm refreshing my emails.
Thank you.
I do not have not received it. I am now going to look in I'm just trying to get now it has come through.
Okay, lovely. Would you be able to quickly
Exhibit U28. Okay.
And the next one should
I'm also
be...
just getting the password, sorry. I'm just writing it down so that I...
No problem.
I'm entering the password. It's currently downloading. It indicates 1 minute left.
Thank you.
Is she going to be looking at the documents on a computer
Yes, Mr. Chair.
as opposed to hard copies?
Yes, we didn't have the opportunity to courier the documents down to Durban because it was a last-minute arrangement from Friday where we were confirmed that she would be testifying via the link. There's just one more bundle that she also has to download. It's in respect of the Tegeta reference, which would be...
When you refer to specific page numbers, will she have no problem identifying those?
It should be no problem, Mr. Chair.
Okay. all right.
Because it's basically our files that have been electronically uploaded.
Yeah.
So I'll quickly check with
Yeah.
her now to make sure she has the black and the red numbers.
Okay, all right.
Mr. Chair, she'll also have to download the Tegeta reference bundle, which would be... So, Dr. Nteta, have you managed to secure the exhibit or Eskom bundle 14?
Okay, I've just downloaded is a U28 in data A affidavit and Eskom bundle 18.
Wonderful.
Is there a second one that I should be looking for?
No, Eskom bundle 18 is the second bundle. That should read the Tegeta reference
Okay,
bundle.
that should. Okay. Okay, I'm opening it. Eskom bundle 18. It is exhibit use, yes, 34, Tegeta reference bundle. And you'd ask that, and there are some, there's writing in black and there's also some writing
In red.
Red. Yes.
That's indeed so. That is actually the two references, that's the electronic pagination for the exhibits that is used at the Commission. We will be referring to the black numbers, so the numbers on your left-hand side
Okay.
on the document.
Okay, noted. All right.
Mr. Chair, my
Continue.
leader has just walked in.
Has he said he wants to take over? If he doesn't say that, you can continue.
He's nodded to me, indicating that he's willing to take over.
Okay. Well, continue while he's busy until he's ready.
Thank you, Mr. Chair. Dr. Nteta, like I've indicated, we're using the black reference numbers. So if we look at U28, the first one, it starts on page, it says Eskom 14, which refers to the exhibit number or the reference, and then the page number is 63. So if you look at page 63 and go up to page 84, you confirm that is your statement?
Yes, I do.
Okay. Ma'am, if you turn then to page 84, you would see the affidavit was signed by yourself on the 5th of July, 2020. You confirm that is correct?
Yes, I confirm the signature. The date I cannot see well, but I confirm the signature.
Well,
I see the stamp of the South African Police. Yes, the 5th of July. Yes.
well, the stamp of the South African Police reflects 5 July 2020, but
Yes.
the Commissioner of Oaths said that you certified that you acknowledged that you knew and understood the contents of the affidavit, which was signed and so on before him at July, on the 5th day of June 2020. Is that July or is that something else? Do you see what I'm reading?
Yes, yes, sir,
Does
I
it
see
look-
what you are reading.
Does it look like July, or is it the name of a place that looks like July? Do you remember the place?
There are
where-
actually two.
You remember the place
Yeah,
where
the
you went?
Yes, the place was Midrand.
Yeah. So there's July, then there's June,
Yes,
and it can't be both.
yes.
What's your recollection? Was it July or June? Or you can't remember?
I can't remember. Right now, I'm inclined to say July because my signature in the above looks like it says 07.
Yes.
So I'm inclined to
Yeah.
say
July.
July.
Yeah. Okay, all right, continue.
I think a simple way to put it would be, ma'am, on the day that you signed your signature, do you remember being at the Midrand police station?
Yes,
Yes.
yes, I
So
do.
then you would have commissioned the statement in front of the commissioner at the police station, and the stamp would read 7
Yes, I
July.
did.
So I think it was just an error where they
Yes.
put in July, June. I think the statement was drafted around June, but signed in July. Great. Ma'am, as indicated, that this is your affidavit to the commission. So for the record, you've confirmed it is yours, your signature, and it's your statement that you've provided. Can you state
Yes,
your...
I confirm.
Okay. For the record, would you be able to place your qualifications?
Just for the sake of completeness, do you confirm that the contents of the affidavit are, to the best of your knowledge and belief, true and correct?
Yes, I confirm that they are, yes, I confirm.
Yes, continue.
Mr. Chair, my silk is asking if he may then now take over with the proceedings.
Okay, that's fine.
May I then be excused?
Yeah.
Thank you for the indulgence.
Yeah.
Thank you, Chairperson.
Yes, Mr. Slegger.
I apologize for the late arrival, Chairperson. I understood that the witness of this morning might take longer than discussed with my learned friend yesterday, but I was told that after 2 he was excused.
Well, when we started in the morning, I specifically said to Ms. Sibia that I would give her 2 hours to finish. And part of the reason why I mentioned that in the open hearing was so that wherever you may be, you would know, because you should be keeping an eye on what's happening in the proceedings. You should know that we were going to finish at about 12. So we didn't finish at 12, so I thought by 1 o'clock you would be here. 1 o'clock you were not here, so I thought at least when we come back at 2 you would be here, and then you were not here still. So later on I had to ask your junior to take over.
DCJ, I hardly watch, but when preparing...
Well, you had to watch if you wanted to, if you knew you were going to have to start after the witness has finished, who had started in the morning. You had to keep an eye or get somebody to tell you if something changed.
I was, DCJ. I was.
Okay, all right. Let's continue.
Yes. DCJ, I've been observing on the issue of the signature of Dr. Nteta's affidavit. Dr. Nteta, on the last page of your affidavit, the commissioner has put a stamp, the South African Police Service, Supply Chain Management Midrand. The stamp shows a date of 5 July 2020. Can you see that?
Yes, I can.
And then the date of 5 corresponds with what is handwritten on the oath, and the month of July, which is misplaced, is put, the month is written in the space for the place. Can you see that?
That has been covered.
Yes,
Mr.
I do.
Slegger.
Yeah. So,
That has been covered by your junior.
thank you, Chair. So we can accept that your statement could have been commissioned on the 5th of July. Chairperson, for the purposes...
Your junior had just started asking her to deal with her qualifications, and when you took over,
Yes.
and she was still to deal with her qualifications.
Yeah. Chair, is it sufficient? The affidavit is in Exhibit U28.
The affidavit has not been admitted as yet, but the part you sought to cover has been covered. I think that if you
wish to
asked me
admit it.
to have it admitted, that can be done, and then you can
Yes,
ask her about, then you can start asking her questions, starting with her employment history at Eskom and her qualifications.
yes.
Do you want me to admit this affidavit?
Yes, Chair, it's Exhibit U 28.1.
The affidavit of Ayanda Nteta, starting at page 63 of Eskom Bundle 14, is admitted together with its annexures as Exhibit U 28.1.
Thank you, Chair. Chairperson, for the purposes of the audience, I could also briefly point out the issues on which Ms. Nteta will be testifying on. Could I do that? Thank you, Chair.
Yeah.
So Ms. Nteta is a former employee of Eskom, Chairperson. She was there in 2015 in the division of fuel, the unit of fuel sourcing within the division of primary energy. So she would have been responsible for fuel sourcing. The points that she's going to testify on mainly relates to the prepayment submission that was made for the prepayment of 659 million rand to Tegeta in April 2015. She will tell the chairperson that she was in fact the person who initiated the drafting of that submission, which was ultimately signed by Mr. Koko and submitted to the BTC in a meeting of the 11th of April for approval. She will also tell the chairperson about her interactions with the Gupta family. In this case, specifically in her affidavit, she addresses her interaction with Mr. Tony Gupta. She will deal with, as well, her interaction with Mr. Ravindra Nath, who was the CEO of Tegeta at the time, and tell the chairperson how the transactions between Tegeta and Eskom in regard to BR Fontaine and this particular transaction of 6.659 million came about. Thank you, Chair.
Okay.
Ms. Nteta, then, in regard to your qualifications, just by way of background and introduction, could you please tell the chairperson what your qualifications are?
Okay. I currently have a doctorate in business leadership, which I obtained from UNISA, School of Business Leadership in Midrand.
I see that you say you also have qualifications in Masters in Business Leadership.
Yes, I have a master's in business leadership, obtained from the same institution. I also have a Bachelor of Arts degree, which is my undergraduate degree.
Yeah.
I assume you obtained your doctorate after you deposed to this affidavit?
Yes, I did,
Okay.
formally.
Congratulations.
Thank you, sir.
Yeah, thank you, Chair. Dr. Nteta, I'll call you doctor then. When did you start at Eskom?
So I started at Eskom in June 2012, I believe it is. And I started as a senior manager within the fuel sourcing division, which falls within primary energy department.
As a senior manager?
Yes, as a senior manager.
I see that from your affidavit, you would have held this position from then June 2012 to about July 2015.
Yes, sir.
And what position did you occupy thereafter?
So after the position of senior manager, I was then in August 2015, I was the acting general manager, also within fuel sourcing, also within the primary energy division. And that was until February 2017, where I was then a senior general manager for primary energy division.
Thereafter?
A position that I held up until April 2018, I'm just trying to remember, where I then left the employ of Eskom.
Yeah. But do you have your affidavit in front of you?
Yes, I'm just trying to get to that.
Yeah, that's in Eskom Bundle 14, Eskom Bundle 1.4.
Yes, sir.
It's on page 64, which is the black numbers on the left, top left-hand corner.
Yes. Yes, I have that. And I have that in front of me.
Thank you. So the period of interest for present purposes is the one from August 2015 to January 2017, when you were the acting GM fuel sourcing.
Okay. Yes, sir.
Well, we could actually take it back to June 2012 because of my next question. Tell the chairperson, when did you have engagements or interactions with the Gupta family or members of the family?
So my interactions with them, I've indicated that I do not recall the exact date, but it would have been, if I was to put a line in the sand, after they had obtained the BR Fontaine coal supply agreement, which they were awarded in, I think it was 2015, where they were awarded that particular agreement.
Yes, now I've looked at the evidence, even your affidavit. I see that that contract was signed on the 10th of March, 2015.
15, yes.
That chairperson you found on page 69 of Dr. Nteta's affidavit, paragraph 6.16.
Yes.
Do you see that, Ms. Nteta, Dr. Nteta?
Yes, paragraph 16, yes.
Yeah,
It was
6
signed
months.
on the 10th of March 2015.
That's right. But
So my interactions would have been close to that.
would have been posed that. But would you please, just before we go into the details of your interaction with them, would you please give us the background to the conclusion of the BR Fontaine contract? In a nutshell, how did that contract come about? What role you played in the build-up to the conclusion?
So that contract came about from my perspective, between June 2012 and December 2012, where I was requested by my then manager, Johan Bester, to engage on the supply of coal from Tegeta. And from that point, there were several interactions with various people from the organization, from the CEO to the general manager, etc. And that culminated in the conclusion of an agreement in March 2015, where we had various negotiations. The final negotiations was with my then manager, Johan Bester, to then conclude the coal supply agreement then.
Now, on page 65 of your affidavit, and I'm always referring to the black numbers on the top left-hand corner, page 65, paragraph 6.3, it reads there that during 2013, I, together with representatives from inter alia, the technical, environmental and coal operations departments within PED, which is Primary Energy Division, is that correct? Just speak
Yes,
up.
it's correct.
Yeah. And the Eskom legal department engaged primarily with Mr. Ravindra Nath and Mr. Satish Mudalia from Tegeta Exploration. During initial engagement that Eskom had with Tegeta, they proposed 2 resources to supply coal from, namely BR Fontaine and BR Fontaine mine. Is this interaction, which you referred to during 2013, should in fact be dated June 2012 and onwards, from June 2012 onwards?
In terms of that particular date, why I'm saying from June 2012, it wasn't exactly in June 2012. I joined Eskom in June 2012.
Yes.
I cannot recall the exact date when Mr. Bester requested that I engage with the supplier. There were several engagements that we had. So I cannot tell you the exact date, but I do believe that there are some emails with regards to that we might get closer to the date.
Yeah. Okay, but is it correct that these engagements would have been based on an unsolicited, if I may use that word, which I see from your affidavit, an unsolicited approaches made by Tegeta?
Yes, those engagements would have been from an unsolicited approach made by
With
Tegeta.
Tegeta. So no,
Yes.
this was not an
If I can-
engagement. Carry on.
If I can just indicate, before they were Tegeta, I believe they were called, I think it was Idwala, but yes, in terms of the gentleman that we engaged with from the organization.
It was the same Mr. Ravindra Nath,
Yes, and Mr. Satish.
Mr.
Mudle.
Satish. So there was no procurement process necessarily followed here.
In terms of a tender that went out, no.
No.
But in terms of a tender, no.
At the time of your engagement at that stage, were you aware that there had been no tender that had been advertised or that had gone out?
Yes, so at the time of my engagement, yes, I was aware that there was no tender that had been issued. In terms of our engagement within Eskom at the time, we engaged with suppliers based on unsolicited offers. So we would get suppliers coming through to us to indicate that they have a potential to supply us with coal, and that is how we would engage them.
When you engage them after they've made that approach to you, unsolicited proposal, would your engagement with them be on the basis that you are just exploring exactly what they have in mind, but in due course a tender would be issued, or was it understood that if it's an unsolicited proposal, there would be no tender issued? You would discuss with them, and if you reach agreement, you conclude an agreement with them. What was your understanding and experience of how Eskom was dealing with such proposals?
My understanding and experience was that we would engage with suppliers to the point of conclusion into a coal supply agreement where they would supply us. At that point, we did not go out on tender, and we would conclude agreements with suppliers based on unsolicited offers.
That was your experience and that was your understanding?
Yes.
And it had happened with a number of unsolicited proposals made by different suppliers in the past?
Yes.
Okay, all right. Or maybe before we move on, you may not have been a procurement person, but I guess being at senior manager level, one should expect that you would know. Did you have any understanding as to what Eskom's justification was for not going out on tender in such cases?
So the justification that Eskom had with regards to the procurement of coal was based on a medium-term mandate that was entered into in 2008 that said that we could then engage with suppliers in order to secure coal. The reason, the rationale and the justification was that in terms of getting coal, the main mandate was to secure it because of the lack of availability of this coal, particularly the volumes that Eskom was looking for, as well as the quality. So it was within the medium-term mandate, and what we were requested to do periodically is to then provide the board tender committee with feedback in terms of how we are faring against this mandate that we had.
You know, I can imagine that if supplier A approaches Eskom and says, I have a mine from which I can supply you with coal, I can imagine that obviously that coal, that is their mine, and that's their coal. If there is nobody else who can supply you with coal, there might not be any issues about not going out on tender. But I leave that aside for the time being. But I can imagine that if somebody approaches you on the basis of an unsolicited proposal and seeks to conclude a coal agreement with you as Eskom, and you do have a need for coal, you do want people who can supply you with coal, there is no reason why as Eskom you can't go out on tender. Let somebody else who might be able to tender or put in a bid, also put in a bid, and this one can put in a bid as well. And then you might either take both if your need is great, or take the one that gives you the best offer. Are you able to say something on this thinking that I'm having? Because you as senior manager, you might have knowledge of the dynamics at Eskom that I might not know. But I'm just saying my immediate reaction is it doesn't look like there would be justification not to go out on tender, because what if there is somebody else who can offer you coal at even a better price that you are not aware of and who has not put in an unsolicited proposal? Do you want to say something on that?
So, yes, I can say something. So the 2008 medium-term mandate was a result of I want to call it an insatiable appetite that Eskom has for coal, and having to look to secure it. So at the time, the thinking was that we should look at all mechanisms that are available to secure coal, and which is why looking in terms of the speed in which we also secure coal, which is why they had the mandate, which was open for a large volume. And it was amended that said as long as you're within this particular volume that they have put in, as well as in terms of the pricing parameters, then the primary energy head would then be authorized to conclude on the agreement. So that was one of the mechanisms that was made available because of the core requirement. The second dynamic comes in terms of the qualities that Eskom specifically looks for. And so they could be a mine that does have that particular quality or does not have that particular quality. So we also would look in terms of those various parameters when looking to secure coal.
Well, you will tell me if this is something that you wouldn't be able to deal with because of the position you held. But it seems to me that that mandate that you talk about couldn't authorize Eskom officials to do something that's unlawful. If the law required that you go out on tender, that's the law. That's what you are supposed to do. The board or somebody couldn't write a mandate that says to the executive, don't bother about the law. Don't go out to tender when in circumstances where the law says go out on tender. You understand what I mean?
Yes.
Is that something you are able to say something on, or is that something you're not able to say something on to try and make me understand why Eskom would not go on tender in these circumstances, would not go out on tender in these circumstances?
No, I would not speak on that in terms of the legalities of that or the specific mandate.
Okay, no, that's all right. Mr. Selega?
Thank you, Chair. Dr. Nteta, but the other aspect is that the BTC mandate of 2008 was not specifically relied upon for the BR Fontaine contract. I see that you refer to it when you deal with the prepayment of the 659 million. So do you know for sure, or are you now surmising as to that being the reason for why the BR Fontaine contract was concluded?
So the 2008 mandate looks in terms of the securing of coal of a specific volume and specific rand per ton, rand per gigajoule. And it would then, so for the BR Fontaine contract, it would be within that particular mandate. Similarly, for the prepayment, for the aspect of the security of the coal, it would be within that particular mandate in terms of that. But when you then begin to talk to, and I'm going to assume that we will talk to that, you talk to the aspects of the of the payment and the finances, then that is a separate matter.
Yes,
I'm sorry, Mr. Selega and Dr. Nteta. I'm going back, I want to go back to the issue that we were dealing with a few minutes ago. Maybe I was being too soft on you to leave the issue where it was. You might not be a procurement person. You might not be qualified in procurement in terms of paper and so on, I don't know. But I would imagine that senior managers in any institution, including Eskom, would at least have some understanding of the basics of procurement, so that even if they might not have deep knowledge of procurement procedures and so on, they would know at least that before you conclude a contract with a supplier, generally you are supposed, Eskom is supposed to go out on tender unless the situation falls within certain exceptions. And if they are not sure, they would ask procurement, the procurement unit or division within Eskom, is it right that we should not go on out on tender on this? Because you would not, as a senior manager, want to involve yourself in a transaction where you might be accused of having breached procurement policies of Eskom or procurement laws that are binding on Eskom, isn't it? You would have that kind of basic knowledge, would you not?
Yes, I would have that basic knowledge. Yes. So when looking at the medium-term mandate, it was the practice within Eskom when looking to secure coal, we would work towards that particular mandate for coal. So I would say that at that time, probably about 80% of the transactions within the division were done within that particular mandate. It was a 10-year mandate open for that period.
Did it, that is that mandate, did it specifically say that procurement policies or procedures need not be followed in those cases where there was an unsolicited proposal?
So I have not looked at the mandate recently, but my understanding and recollection of that particular mandate, it indicated in terms of what should be done with regards to concluding coal supply agreements. So it would look in terms of those qualities and in terms of also looking at the price. And also it was quite specific about the volumes. So it indicated what should be done. So, I think your question to me was that, does that particular mandate then override the laws of the country?
And the policies which I assume Eskom had in relation to procurement, which a lot of state-owned entities had, which require that the entity should go out on tender, should issue tenders unless a particular case falls within certain specified circumstances, exceptions.
Correct.
Yeah, so
the history of...
Yeah,
sorry,
continue.
So the history of the institution in terms of where primary energy comes from, it was in terms of a standalone unit that had its own managing director at the time. And that is where the policies and the procedures, etc., came from, that in terms of this particular standalone unit has its unique nuances, and therefore the procurement processes would be then dictated by, at the time, it was that particular mandate. But I am hesitant to get into the details because I would like to rather allow those who know better to talk about the history of that particular mandate, where it comes from, etc.
No, that's fine.
So the primary energy division did do its procurement in a particular way.
No, that's fine. But obviously, what you are able to do is talk about what your own understanding was, which may or may not be in line with what they will say was the position. But you certainly had your own understanding of what was supposed to be done and what was not supposed to be done. Is that right? But
Correct.
your own understanding, you are saying, was that with regard to unsolicited proposals, there was, to your knowledge, no need or requirement to go out on competitive tender. Is that right? That was your understanding?
Yes.
Yes.
That was my understanding, and that was the practice at the time.
And that was the practice at the time. And it's in line with your understanding of the mandates that you have talked about.
Yes.
Yeah. Okay. All right. Mr. Silega.
Thank you, Chair. Dr. Nteta, well, the mandate is not attached to your affidavit. I know that you've referred to it elsewhere in your affidavit, but it's not attached. I have had the opportunity to see that mandate, and the question which the chairperson is asking, whether the mandate allowed a deviation from a procurement process, that mandate you would have seen, in fact, it doesn't have the deviation from a procurement process. The mandate contemplated the conclusion of medium-term contracts. You would recall that.
Yes.
Yes. And the mandate did not envisage unsolicited offers. So you had to determine as Eskom that you needed coal, and then you could invoke that mandate.
Yes.
There is a paragraph of particular interest in your affidavit, which is on page, it starts on page 64.
Mr. Silega, before you proceed, can arrangements be made for me to see that mandate and for Dr. Nteta to have access to it, because I think we probably won't finish with her evidence today.
Yes.
If we continue tomorrow, she would be able to refresh her memory on what it says and maybe answer some questions tomorrow.
Yes,
Yeah.
indeed, Chairperson. Dr. Nteta, I was then referring to page 64, that paragraph on 5.2, paragraph 5.2 of your affidavit. You talk about the reasons why you left Eskom in that paragraph. You give a primary reason, then you give what you say are secondary reasons. Are you on that page, 64, paragraph 5.2?
Yes, sir.
You are
Yes,
there?
I now am.
Yes. So the primary reason you said it was for you to study, to pursue your studies. You see that?
Yes.
And then at a secondary level, you give quite an extensive explanation there, which the essence of which is that you were essentially moving away from pressure being brought to bear on you by the executives to do certain things. Speak to me.
Yes, so my affidavit indicates that my primary reason for leaving Eskom, yes, is to pursue my studies. The secondary reason was that the area that I was within procurement, which is the primary energy division within fuel sourcing, there was a lot of interest in terms of the transactions that were in that area from my superiors up until board level. And at the time, there had been a new board that was entering within Eskom, and what I noted in terms of the new board that came in, there still seemed to be the same interest in terms of coal transactions. And I just felt that I did not want to partake in it.
So the interest you are referring to, are you able to explain to the chairperson what you mean by that?
So with regards to interest in terms of coal transactions, throughout my tenure at Eskom, I would be asked about specific transactions as to how far we are within negotiations, how far we are within concluding. We from the fuel sourcing department are required to put together documents that go to the board tender committee. So I would be asked questions in terms of the various transactions at different times. And in my opinion, I just felt that one, my level within the organization, I should not be asked those questions. There are people who are more senior to me who should be asked those questions. And secondly, that in terms of my level, I do the transactions. And so I did not want to continue to have that kind of pressure. I was hopeful with the entering board that it would be different, and it was not.
Yeah. Now, are you able to tell the chairperson whether or not in the conclusion of the BR Fontaine contract, did you have the same experience of pressure being brought to bear on you or interest being shown in this contract?
Yes, I did.
So you did have the same experience?
I had, yes. I did. There was questions I was being asked to report in to my immediate manager in terms of where the transaction was. I had to report in. The last negotiations that we had, my immediate manager joined into those particular negotiations. That was the last and final negotiation before the conclusion.
I imagine that your immediate supervisor or manager wouldn't be one of the people that you were concerned about in terms of asking you questions about transactions that you were doing, because obviously your immediate manager or supervisor is entitled to ask you to see what progress you are making, and maybe if he or she thinks the progress is slow, to push you to try and conclude the transaction as soon as possible. You accept that?
I do.
Yeah. So I suspect that the people, the pressure that you are talking about, which you seem to have found unacceptable, would come from other people. You are not talking about your immediate manager. You are talking about pressure that was directed at you, or questions that were being put to you, or inquiries by other people. Is that correct?
Correct. So with regards to the conclusion of the particular transaction with BR Fontaine, yes, I would get questions from my immediate manager, and the frequency of the feedback that I had to give was weekly. I also would have to provide that same feedback to my manager's immediate manager in terms of the progress in terms of that particular transaction. We as a department, Primary Energy Department, were also called in to a meeting, and it was only our department by our chairperson who spoke in general about how we are interacting with our suppliers, which I also felt was inappropriate. And I'm providing you with the examples.
When you refer to your chairperson, now you're talking about the chairperson of the board of Eskom at the time?
Yes.
Who would that have been at the time?
Mr. Tsotsi.
Mr. Tsotsi. Okay. So let me go back to getting more clarification. The people who were putting pressure that you found unacceptable on you, would some of them have been members of the board of Eskom?
So the member of, for this particular transaction for BR Fontaine, is that the question, sir?
No, I'm still at a general level. You said the secondary reason why you left Eskom was because of pressure that was being brought upon you in regard to various transactions. So I'm talking at a general level at this stage.
Okay, thank you for that clarity. At a general level, on coal transactions, the main, in terms of the chairman of the board, I gave the example of them calling us in and discussing in terms of our, how we engaged in terms of the suppliers, and that should be at board level. Yes. So, it would mainly be at that level, but they'd also be within the executives.
Pressure would also come from within the executives other than your immediate manager?
Other than my immediate manager, yes.
Yes. Obviously, you regarded this pressure as not legitimate, is that right?
I regarded the pressure as that it is not required and it is not necessary.
Yes.
Why I say so is that whether the medium-term mandate is right or wrong, we have a process that we follow. And I provide the feedback to my immediate boss. He, as you've indicated, if he felt I was working too slow, he would let me know, etc. But I just felt that if I have to give feedback every week on the transactions, and we deal with quite a few transactions, then I'm providing more, the work that I'm doing is providing more feedback than actually attending to the transactions. And I felt that was inappropriate.
Yes, Mr. Slager.
Thank you, Chairperson. Dr. Nteta, your immediate boss was Mr. Johan Bester.
Correct.
Is that correct? So providing feedback to him would be in order. Then you have mentioned the executives who would put pressure on you. Do you mind telling the chairperson the ones that come to your mind in this regard?
So, for example, Mr. Johan Bester reported to the Senior General Manager for Primary Energy. And I would give feedback to that Senior General Manager for Primary Energy. And I felt that is not required because I do have an immediate boss, and should he require information, he should receive it from there.
Who was the Senior GM Primary Energy at the time? 2012, 2013?
It was Mr. Mboweni.
I have seen the affidavit of Mr. Bester. When talking specifically about the BR Fontaine contract, he details the time period taken prior to this contract being concluded on the 10th of March. So, as you quite correctly say, the engagement with Tegeta or the approach by Tegeta dates back to 2012. 2012,
Correct.
Thank you, 2012, 2013, 2014, that's 3 years. And only in March 2015 was the contract concluded. He says, sorry, just repeat your answer.
I said correct.
Correct, thank you. He says then, during that time, even though you were reporting to him, he observed that you were being requested by persons like Mr. Mboweni, Mr. Mabelani, and Mr. Machela Koko to report directly to them. What's your comment on that?
Yes, so as I indicated, the weekly report that I had to write was to Mr. Mboweni, and at his request, and I would then copy Mr. Bester because I wanted him to know that I'm doing these reports, and I also informed Mr. Bester that I'd been requested to provide weekly feedback in terms of the transaction, the progress on the transaction.
Yeah, but he specifically says he had concerns that you had to be asked to report directly to Mr. Koko in regard to this BR Fontaine negotiations. Your comment?
I didn't report directly to Mr. Koko with regards to the BR Fontaine negotiations. I think what Mr. Bester, however, I have not seen his affidavit. I think what he's referring to is that at the negotiations that we had with BR Fontaine, I did receive a call from Mr. Koko where he asked me where Mr. Bester was. And I went to Mr. Bester and told him that Mr. Koko is looking for him during those when we're in those negotiations.
So he testified in the first phase of the commission. I'll provide you with his affidavit, but there's a passage in his affidavit where he says, I always knew that there was interest in the Tegeta BR Fontaine contract from higher up. So that seems to resonate with what you've said earlier. Even since 2012, but significant pressure and focus came from the start of 2015. BR Fontaine by then had its water use license, and we had run out of legal excuses to keep betting them away. From the beginning of 2015, we had to provide Mr. Machela Koko with weekly progress reports. Also, I suspected that Mr. Koko was engaging Ms. Ayanda Nteta directly, although she reported to me. He never directly put pressure on me, but he did on her. Your comment on that?
So with regards to that, I do not know where my reports went, my weekly reports went to. So Mr. Bester would be better, he would be better able to advise as to where those particular reports went to. I know that I sent my reports to him and to the senior general manager, which is Johan's boss. Where they would go further, I don't know.
But can you say in regard to putting pressure, whether you experienced that pressure was being brought to bear on you by Mr. Machela Koko?
Not with regards to that particular transaction.
Okay. Mr. Bester continues, and as I said, I'll provide you with his affidavit. In another paragraph, he says, I realized later that Mr. Koko and his handlers had two games running, each with their own timelines. The primary one was to get rid of Finance Director Ms. Tsulofelo Molefe and Group Capital Executive Mr. Den Marukani. In hindsight, it makes sense why we came under such pressure from Mr. Koko and Mr. Mboweni, as those pulling the strings needed to effect the suspension of the 4 executives, including Mr. Koko, as a ruse. In brackets, he puts as a ruse against the name of Mr. Koko. And the BR Fontaine contract was taking longer than they had anticipated, and I guess they were worried that without Mr. Koko, they would not be able to apply any leverage over PED, which is primary energy. It is well documented that the contract was signed on 10 March 2015, and that Mr. Koko was suspended on 11 March 2015, the next day after the contract was signed. But few have joined the dots. So you understand the message is conveying. So from 2015, he says, pressure was brought to bear to have this BR Fontaine contract concluded as soon as possible. Because now, when he reflects back, he can see that, okay, those who were putting pressure, they would have realized that without Mr. Koko, the contract may not be concluded. You follow the reasoning?
Yes, I do.
Do you have any comment on that?
My comment is that, as I indicated to you, the final negotiation that we had was when Mr. Bester joined me in the negotiation, and that was final. At the time, I just thought he felt I was taking too long, and that's why he joined, because he wanted to conclude the agreement. So he, and I will thank him for that, and Mr. Mboweni would have tried to shield me from the pressure that they were receiving. So they would ask me to do those weekly reports, of which I did to them. As I indicated to you, I don't know where they went, where those reports went to after that.
I see.
So I understand his reasoning.
Yeah. But you say he would have tried to shield you from the pressure.
I will assume so. As my direct manager, he would try and do that.
Just one
So
more.
he is.
Go ahead.
Sorry?
Just go ahead. You may proceed.
No, I said I will assume that he would have done that. So your statements that you've read to me say that primary energy was getting pressure from outside of primary energy. The pressure that I was feeling and received was from within primary energy, from Mr. Bester as well as Mr. Mboweni, who are within. So they would have received it elsewhere and then filtered it and then asked me to do those weekly reports.
Yeah, but we were also going down that line because we thought you could also tell the chairperson more about what you say in that paragraph 5.2 as your secondary reason for leaving, that you experienced pressure from the executives and the board members. So we're seeking to have you say more to the chairperson on that.
Yes, so the chairperson had asked me to talk about it in general, of which I did. So the events leading to the conclusion of the BR Fontaine contract, as I've indicated, was the having to provide constant feedback. Other events that happened was that primary energy as a whole was called into a meeting by the Eskom chairperson. I thought that was unprecedented. So those are the kind of pressures that I felt that as we deal with the coal transactions are unnecessary.
Yeah. Let me read just the last passage from Mr. Johan Bester's affidavit. He says, the medium mandate had worked well until then. And I suppose he's talking about the 2008 mandate for medium-term contracts.
Yes.
It had worked well until then. And in fact, I still believe that even the BR Fontaine contract was valid and properly negotiated, and although entered into under pressure, did not compromise Eskom. Eskom was compromised when Mr. Koko suspended those trying to implement the conditions of the contract. The system wasn't broken. People like Mr. Koko tried to compromise the system that was in place, and people like Mr. Mboweni appeared to be powerless to push back. Interestingly, in this instance, Mr. Mboweni signed. He was probably told to do so to ensure that the validity of the contract couldn't be questioned. You may comment, if you have any comment, in regard to the first part which I read about the system not being broken, but that Mr. Machela Koko tried to compromise the system that was in place. Whether you have any knowledge of this? And people being suspended?
I will agree with Mr. Bester in terms of the medium-term mandate, because I do believe that it served Eskom well. And that particular agreement fell within that medium-term mandate. With regards to the suspension of executives, etc., I will not comment because I really did not follow that in detail, so I would rather not comment on it.
I see. Thank you. So the contract is concluded, the BR Fontaine contract concluded on the 10th of March, 2015. You say you would have had interactions with the Gupta. In particular here, you specifically mentioned Mr. Tony Gupta after the conclusion of that contract.
Yes.
Now, please relate to the chairperson how those interactions came about, how many were they, and what did they entail?
Okay. So the interactions, and why I say it was after the conclusion of the agreement, because the first interaction, I was actually requested by Mr. Nath, Ravindra Nath, who is the CEO of the organization. We would engage...
CEO of which organization?
Of Tegeta.
Yeah.
Sorry. He had requested that I meet with him to discuss, at the time we were discussing the volumes, because the agreement that was put in place had a ramp up of the volumes based on the mine being able to produce the coal. So at the time we were discussing in terms of that particular ramp up of the agreement. So he requested a meeting with myself.
Hang on, Dr. Nteta, hang on.
Yes.
Your interactions with Mr. Tony Gupta, did they happen after the conclusion of the BR Fontaine contract or not?
Yes,
or some
they did.
Happened before and others after?
It was after.
They happened after the conclusion of the
Yes.
BR Fontaine contract?
Yes, they happened in the execution of the contract.
In the execution of the
After.
contract? Yes, in that event, Mr. Slegger, we need to cover the evidence up to the conclusion of the contract. I was saying that in her affidavit, it appears that up to paragraph 6.16, which is at page 69.
Yes, Chair.
Unless I've missed something, I seem to not have seen where before that paragraph she talks about the signing of that contract. I see that at 6.16 she says the CSA was signed by Mr. Mboweni on 10 March 2015. Is that the BR Fontaine one?
That is 6.60 meters.
Yeah, if I've missed something, maybe I have, but I would like the evidence of the discussions and negotiations and the happenings that preceded the conclusion of the contract to be covered, so that we know this is how the contract got to be concluded. And then if we then deal with the execution of the contract and what happened in connection with the execution of the contract, we can then deal with that. Then we know that it's after the conclusion of the contract.
Thank you, Chair. Dr. Nteta, you follow?
I follow.
Yes.
I am concerned because I thought we were dealing with the prepayment, but I will respond to the questions to the best of my memory.
Yes, there is reference to we've had some discussion about the conclusion of the BR Fontaine contract. And it seems to me to be left hanging. But both the evidence leader and yourself, Dr. Nteta, you would know more about the background to the affidavit. Both of you can alert me to something that I might have missed. But for the story and the evidence to be easy to follow, it's much better if we say, this is what happened, the contract was concluded, and then where the prepayment fits in, then obviously that can be dealt with where it should be dealt with. Mr. Selega, you will tell me if there's something I've missed.
No, Chair. I think you haven't missed anything, Chair, but you are correct that we haven't given the chairperson the details as set out in Dr. Nteta's affidavit in regard to the BR Fontaine contract. So Dr. Nteta, maybe we could go into the details insofar as you have set them out in your affidavit, because they are there in your affidavit. So, and that starts on page 65 of your affidavit. Just by way of a guidance, under paragraph 6. Indeed, I had certain questions to ask you in regard to the progress and exchanges made during the negotiation stages. So what we have established from you is that the negotiations or the approach by Tegeta would have taken place back in June 2012. So Tegeta would have come to Eskom and said, we would like to offer coal to Eskom. Correct? Supply coal to Eskom.
Yes. So the engagements with Tegeta preceded myself. They came to Eskom and they engaged with, and please excuse me, I think there are emails to the regard. They dealt with various seniors within Eskom prior to my engagement. I just cannot recall the exact date.
So prior to you being employed at Eskom?
Yes.
In fact, Tegeta had already approached Eskom to supply coal to Eskom.
Yes.
When you came, when you became employed at Eskom in June 2012, you became engaged in interactions or negotiations that were already ongoing.
So yes, so prior to my employ at Eskom, Tegeta had been involved with various people. Apologies that I just cannot get all the specific names. Yeah. I joined Eskom late, not as in terms of the day that I joined, then I was asked to look at Tegeta. I joined Eskom, and I'm going to estimate perhaps 6 to 10 months after I had joined Eskom, Mr. Bester then asked me to lead the negotiations with regards to this particular transaction.
I see. That engagement is what you deal with in paragraph 6.3 of your affidavit on page 65. You say
Yes.
during 2013.
Yes.
So during 2013, I, together with representatives from inter alia, the Technical, Environmental and Coal Operations Department within PED and the Eskom Legal Department, engaged primarily with Mr. Ravinder Nath. So we've read that passage. And they were
Yes.
proposing to offer Eskom coal from two mines, Fontaine and BR Fontaine.
Yes.
Fontaine did not succeed, only BR Fontaine remained on the table as of that date. Just speak to the
Yeah.
mic.
So at my first engagements with the supplier, they had indicated they had two offers. The Fontaine, why we did not progress with that, because in terms of one of the requirements for the conclusion of an agreement is that the source has a water use license. So if my memory serves me correctly, the Fontaine was further back in terms of that application for a water use license. And that is why we did not continue with this, because the BR Fontaine source was further along in terms of their application. There could have been other environmental issues that the environmental team may have brought up, which I cannot recall at this time.
Yes, you in fact do refer to environmental issues in regard to Fontaine in the last sentence of your paragraph 6.3, but that's on page 66.
Okay, yes.
Well, talking of the water use license, that's P66, Chairperson, the top paragraph. Talking of the water use license, in 2012 and 2013, Tegeta also did not have a license in regard, water use license, in regard to the BR Fontaine mine.
Correct.
Could you have concluded a contract with them at that stage?
No. So in terms of what we would do in terms of unsolicited offers, we would engage with various suppliers and we would advise them in terms of the requirements for the conclusion of an agreement. So because particularly when it's new sources, there are a lot of things that would happen, and the negotiations generally take about 18 to 24 months, unfortunately. And we recognize that at that time, a water use license would take about 18 to 24 months. So we would engage with various suppliers on aspects in terms of their coal, etc. There's also options in terms of the environmental issues. If they do a box cut and we get coal, in terms of from the box cut, there are certain requirements that would not be as onerous as a full-blown mining. So we would engage with suppliers. At some point, and there is a memo, which I would ask the employees at Eskom to find, where the senior general manager then indicated that from this point onwards, that we should ensure that we do actually we conclude only agreements with them. So to answer you in a long-winded way, we would engage suppliers, even if they didn't have a water use license, but we would not conclude an agreement.
Yes. And that engagement with a supplier who doesn't have a water use license, I mean, what would it entail?
So the engagement would be looking in terms of the qualities that they have, would look in terms of the pricing that they have to offer. We would also look in terms of the potential legal agreement that we would look at. So there'd be quite a few engagements, different aspects. whilst we are also, whilst we're reminding them that they need to, we also ask for progress in terms of how far they are in terms of their water use license and remind them that they would need to have one.
You know, let me-
Previously, we would actually conclude agreements without a water use license.
Yes. When you talk about negotiations would take 18 to 20 months, I am reminded of the tender process that was ongoing in April 2016, where, and that was in respect of the Arnott power station, supply to Arnott power station.
Yes.
In April, when the question was asked, how long is that process going to take? You say you responded to the BTC members on a teleconference that it will be completed in September 2016.
Correct.
Which is much less than 6 months.
Correct.
So how do we understand, how should we understand your explanations?
So one of the things that I tried to do when I was acting general manager for fuel sourcing was, one, to institute issuing out of tenders, and to then have, to try and get a more robust process in terms of the tendering process and requirements, and to try and streamline it so that it takes a much shorter time. And that is why we were able then to I was able then to say we anticipated to be concluded in terms of September.
So are you saying that explanation would apply in 2011? That a shorter time period?
No, no, so that explanation would not have applied in 2011 because the process at the time was looking, one, in terms of what the requirements were different. And so, two, it was looking in terms of an unsolicited offer where the suppliers is then indicated that we need X, Y, Z. The practice of what would happen is that we would indicate to the supplier that we need X, Y, and Z. The supplier would then go away and we would not actually give them any timeline that come back to us within 30 days or something like that. We would actually just wait for the suppliers to come back, and some of them took 2 to 3 months, and then they would come back once they're able to rectify an element that we'd ask them to rectify. So the process in going out on the tender, we really tried to streamline it and try and do it more efficiently and effectively.
Yeah, I would have thought where you are approached by one supplier, unsolicited, they have all the information, that would be a more expedited process than when you go through a tender process.
It could be if the supplier then came back timeously. But the general practice is that the suppliers, some suppliers would come back in 2 weeks, 3 weeks, other suppliers would come back in 3 months. And we would leave it open for them to come back when they are ready. Yeah. Whereas in a tender, you have to submit everything by a certain time. And we were quite stringent in terms of what are the requirements that we want them to put in and what we were evaluating to try and make it more efficient.
Mr. Slater, we are at 4 o'clock now. Sometimes we will work until late, but it doesn't help to work until late if later in the week we are going to have days that might not be used. So what is the position with regard to other witnesses tomorrow and beyond?
Chair, I believe Mr. Kuku is coming tomorrow.
Okay.
He will take us the whole day.
Yes. 3-3 notices in regard to his evidence been sorted out?
Not yet, Chair.
Well, if 3-3 notices have not been sorted out, how are we going to proceed with his evidence?
Yes, Chair. I intended speaking with the chairperson about it so that I could also communicate.
Well, let's talk about it when they are here tomorrow, because they are affected.
Yes, Chair.
And after that, the next witness, and beyond, what is the position?
On Wednesday, we had scheduled Mr. Anoj Singh.
Mr.?
Anoj Singh.
Yes.
I had a meeting with his attorney and counsel, I think last week Friday, Chair. There is a default of filing an affidavit on his part. They want to regularize that.
They want?
They want to regularize that. And I know...
Why have they not filed it up to now? As I understand, there was a 10-6 directive.
Absolutely, Chair. I have written to them a letter, Chair.
Yeah.
Setting out the position. And,
And I guess with regard to him, there are no 3-3 issues. There are no Rule 3-3 issues with regard to him, because I take it most of the time he is implicated and he is responding to that.
Yes,
Or what is the position?
we haven't seen his affidavit, Chair.
Yes, I mean from
yes.
your side, you are not able to say there are problems with 3-3 notices because there's nothing you were supposed to serve on other people.
Correct, Chair.
So he has been
Summoned
he has been served with a summons
Yes.
for Wednesday.
for Wednesday.
Therefore, he should be here. And when he's here, he's going to need to explain why he didn't comply with the 10-6 directive.
I have indicated that much to his
Yeah.
legal
So
representative.
he must be here, and he'll need to explain that. So that seems to be fine with regard to him.
Yes, Chair.
And from what I remember, the deadline by when you are supposed to furnish an affidavit in terms of the 10-6 directive has long passed.
That was the 4th of September, Chair.
So it's completely unacceptable. Well, he'll need to take the stand here and explain. So that's fine for Wednesday.
Yes.
And how he could be quite long in terms of his evidence.
Chairperson, the way I've planned them is to be a full one day with them.
Yes, but would he, or by the way, he would cover Eskom only.
Yes.
And he would not cover Transnet. He would
No.
have to come back for Transnet.
that's
But
right.
your estimate is that one day would be enough for him?
It should be enough, Chair.
Yeah, okay, all right. And then Friday?
Then Thursday, before Friday.
Oh, Thursday, yeah.
Yes. Thursday, then, we have Ms. Musilo and Bianca Goodson. We have also scheduled Ms. Matsietsi Mkolo.
Yeah,
And then Friday is Mr. Brian Molefe.
yeah, okay. And with regard to Mr. Brian Molefe, how much time have you considered to be adequate? Is it a one day also with him?
One day, but shorter than a full day.
Yeah,
Yeah,
okay,
shorter than a full day.
okay. Now, persons who implicated Mr. Anoj Singh and Mr. Brian Molefe, have they been given whatever affidavits? I know you said Mr. Anoj Singh has not filed an affidavit. But I know that Mr. Bramleffe did file affidavits, I think. Have they been given to the witnesses who implicated them, and have those witnesses commented on their version?
Mr. Brian Molefe's affidavit, which I can't recall offhand. I know we have exchanged the affidavit of Mr. Koko, certainly. And we would have also exchanged the written submission of Mr. Anod Singh at the Parliamentary Portfolio Committee with the witnesses. In regard to Mr. Brown Molefe, I can't recall offhand. And I know that he doesn't implicate people as such.
Yeah, he might not implicate them, but they might have something to say about his version.
Insofar as he mentions them, yes. I think I've exchanged his affidavit with Ms. Suzanne Daniels. Chair.
Yeah, you must just check, because the best scenario is where you have got all the information when the witness takes the stand.
Yes.
Yeah.
Yes.
Okay, well, in that event, I think we should continue at least with this witness until 5.
5, okay.
And then we take it from there.
Thank you, Chair.
Okay, all right. Judicial Nteta, we are going to continue until 5 o'clock. Is that all right with you?
That is fine, sir.
Okay, all right. Mr. Selega?
Thank you, Chairperson. So, Dr. Nteta, you were explaining the time period it takes to negotiate this agreement. And I was saying to you that it seems to me that if a supplier comes to you unsolicited, the process might be expeditious as opposed to when you follow a tender process, but you have given your explanation. Can I ask you this? Because you seem to have given two different answers. On the one hand, when I ask you, whether could you conclude an agreement with Tegeta in respect of BR Fontaine if they didn't have a water use license, you said no. But then you gave an explanation. Subsequently, you said in the past you did conclude agreements with suppliers who didn't have a water use license. So which answer applies?
So when I said we, I said Eskom has concluded agreements with suppliers without a water use license. There was a memo or a directive that was sent through by the senior general manager at the time that indicated that we must ensure that a supplier has a water use license. And that was in the time of the engagements with BR Fontaine. So I repeat that for BR Fontaine, we could not have concluded the co-supply agreement unless they had a valid water use license.
Okay.
They were able to produce it.
Okay, I understand. So at the time of the BR Fontaine negotiations, a new dispensation was introduced.
Yes, yes, a new dispensation was introduced. However, yes.
Okay. So in that dispensation, you were precluded from concluding a co-supply with a supplier who didn't have a water use license.
Who was not able to produce one, yes.
Yes. Because
yes?
Yeah. Because without a water use license, they're precluded from mining. They can't mine.
I don't want to answer that because that's on the environmental side, because I think they can mine on a box cut, but I'm really not an expert to the extent of that, yeah.
In those cases where in the past Eskom did conclude co-supply agreements with suppliers who didn't have a water use license, do you know whether it would have been a condition of the agreement that they obtain such a license, or as you understand it, the position was that would not be a condition? To say they must obtain the water use license within a certain period, and if they didn't get it, then the agreement would fall away.
That is my understanding, but I'm not confident on that understanding because I personally did not do it.
Okay.
But I would make an assumption that it would be a condition that you must have it within a certain period.
Okay, all right.
Thank you, Chair. So you personally have no experience concluding a contract with a supplier who didn't have a water use license?
Not that I'm aware of.
You personally. Okay, now let's go through this period of negotiations in respect of the BR Fontaine. I'm on page 66 of your affidavit. 66.
Yes.
Now, there is an aspect I want to raise with you during this negotiation period. Because in November 2014, you say you send an email to Tegeta. And that email attached the supply agreement.
Yes.
Now, maybe you can explain, because at this stage of the negotiations, Tegeta hasn't obtained a water use license, and you have a memorandum that you have referred to, which introduces a new dispensation that you can't conclude a contract with a supplier who doesn't have a water use license. So can you explain to the chairperson, why did you provide them with a coal supply agreement at a time when you are precluded from concluding a contract with them?
So the practice at Eskom is that particularly for suppliers that have not engaged with primary energy and have not seen our coal supply agreement, would be to send them a copy of the coal supply agreement so that they have an opportunity to view it, provide comment on it, and if there are issues that they believe would be a concern, they're able to raise it, and then it also becomes part of the negotiation process. Because the process in terms of concluding the supply agreements, as I indicated, can sometimes take 18 months, 12 to 18 months, we try and do as much as possible in parallel. So the email that I would have sent to them would have been a copy of a draft coal supply agreement. I stand to be corrected, but I do believe in my email, I do indicate to them that it does not, you have nice legal words, but it does not constitute an agreement. And so I did put a disclaimer in that email, but it was an opportunity for them to have a look at that agreement. We do that with suppliers that do not, have not engaged and do not know our terms and conditions, because our supply agreements are about 65 pages. Yes. Eskom supply agreements are 65 pages.
Mr. Selega,
yes.
The events leading to the signing of the agreement that Dr. Nteta deals with in her affidavit, you would know how important they are,
Yes, sir.
to be covered by way of oral evidence. If there is no particular significance to them, things like Mr. Bester took over the chairing of a certain meeting and so on, we can move on. Yes. But if they have a particular significance which emerges later, then that's fine. So I know that I said we hadn't covered the conclusion of the BR Fontaine contract, but you would understand the significance of some of these things better. If there is no significance, they were just put in there just to indicate what happened before the conclusion of the contract, then you don't need to dwell on them.
Okay, thank you. I understand fully what the chairperson is conveying to me. Dr. Nteta, on this very point I'm at, the email that you send, did you send it on your own accord, or were you told to send this email?
I would have sent it on my own accord so that they can be aware of the agreement, because I've done that before for new suppliers, and we do that for new suppliers.
I see. You also talk about tests that were conducted in respect of the coal that was to be supplied by Tegeta. Can you recall what the test results were? Because I don't see it in your affidavit.
I think there were several tests that were done with several reports, but the members of the technical team would be better placed to talk to those tests, because that would be their responsibility. Okay. So I think there was a Q scan done, there were several tests.
Yes. Then the water use license was only granted in December 2014, and Mr. Johan Bester said thereafter there was pressure brought to bear, at least on him. He thinks there was also pressure on you, but you have explained yourself. Then in 2015, talking of 2015, and I'm now on page 68 of your affidavit, there's a request you refer to for Tegeta to be registered as a vendor.
Yes.
But even at that stage, Tegeta hasn't signed the agreement with Eskom. You recall that?
Yes.
Because now things seem to move fairly fast after they've obtained the water license. In fact, it took only less than 3 months for that agreement to be concluded on the 10th of March, 2015. Before I go into that, can you explain, if you know, what was the delay from 2012 to March 2015? For 3 years.
I can only talk to the period that I was engaged with them. And I would say really the major delay, which is an issue when we have unsolicited, is that we would discuss certain elements with the particular supplier, and then they would then go away and attend to those issues. They would then come back to us when they are ready to do so. So at times, and I think there are some minutes that I attempted to do, you would see that there's a month or two delay where the supplier is attending to something or other. And that is the main reason why it takes long, because the suppliers normally take a while to come back to us.
Yeah. And I'm grappling to understand go ahead.
So, and I'm talking to the time when I was engaged with them. Prior to that, I think they came to Eskom in 2011. I stand to be corrected. I do not know what the delay was.
Yes. Yes, no, correct. We're taking your engagement from 2012, isn't it? After June 2012.
Yeah, I'd say 2013, yes.
Yeah. And I'm grappling to understand what are these issues, because you only gave them a copy of the draft agreement in November 2014. I mean, this is where, if you like, serious engagement takes place, and they will go home and look at the draft, do comments, and so on and so forth, and then come back to you. And we can see it's a short period of space, from November 2014 to 10 March, when the agreement was signed. It's about 4 months.
Yes.
So what was the delay for 3 years?
So the delay would be a few things, as I've indicated, and if you look at some of the minutes, we might say to them, some of the delay also is from Eskom side, where we were doing a combustion test, and that takes a bit of some time. It could be that for whatever reason, they would be attending to certain issues. It could be that maybe they are not prioritizing it. I cannot answer to the reasons why they delay, but it is not, I want to say it's not uncommon, because a lot of times suppliers will come to Eskom and say, I have coal, what do you need? And then when we advise them what we need, then they will go back and sometimes they can even take 6 months to get whatever is needed from Eskom.
Yeah, so didn't the reason have to do with the water use license or the absence thereof?
So, yeah, I was about to say that it could be that they did not prioritize this transaction because they understood from my engagement with them that, you know, we can go as far as we can, but until you've got your water use license, we cannot conclude an agreement. So they could have decided not to prioritize it, but I don't want to speak on their behalf.
Yeah. But then also on Eskom's side, whether you would push enough, hard enough, if you know that they don't have this license.
Yes, so in general, we would advise in terms of the suppliers, Eskom would advise the suppliers what is required. And generally, we don't always follow up with them, you know, to say that, okay, you have not come to see us after 2 months, what is the issue?
Yes.
Because we would also be dealing with other suppliers at the same time.
Yes. But now here we see before March 2015, before the signing of the agreement, you take steps to have them registered as a vendor.
Correct.
Correct? But it doesn't end there. You do say in your affidavit that you told the vendor department or the vendor management at the vendor management department that Tegeta has been awarded a contract. That's in paragraph 614 on page 68. Now, explain that to the chairperson, because you don't have a contract with Tegeta. You're going to be placing them as a vendor on Eskom's database. But you don't only do that, you tell the management that, in fact, we have already awarded a contract to them when you have not at that stage. This is in February 2015. I wanted to suggest to you a possibility, but maybe I should let you explain to the chairperson. Why do you take the steps? Why do you do this?
So we negotiated with Tegeta in January 2014 with Mr. Bester. At the end of that, Mr. Bester sent them through offer letter. And in terms of that, that's one of the, we have in the past, and it is not correct, had coal supplied to Eskom based on that offer letter. Because it sets out the pricing, volumes, and qualities. And that then constitutes an agreement that we have with a particular supplier. So we had done that. Also, having had the discussion with Mr. Bester, he understood that from the vendor requirement side of things, it takes some time in terms of their additional requirements that the supplier has. So he had requested that I get that process going to get them registered while we are also finalizing the longer term supply agreement. So my email is incorrect. I should have said that we have sent them a letter, an offer letter, and not necessarily to say an agreement. However, we have wrongly so had coal supplied based on those offer letters.
Wrongly, you say?
Yes, it's not often,
Yes.
and it is not best practice. I agree.
Yes, okay. What I thought was going on here, and tell me if I'm incorrect. I'm looking at the context of the affidavit of Mr. Bester. He talks about pressure being brought to bear on him. I'm looking at also what you have stated is the intervention by the interest in this contract by the executives and some of the board members, and putting pressure on you, asking you every week what's going on. I thought what was happening here was a reaction to the pressure that was being brought to bear, was as a consequence of the pressure that was being brought to bear. Your comment?
So having had your affidavit, the affidavit of Mr. Bester read to me right now, and looking in terms of that period from January to March, where I was being asked to provide weekly feedback, and Mr. Bester's involvement, because prior to, let me say, December 2014, he was not involved in the transaction, but after, in 2015, he was. So having put all that together, I can understand why Mr. Bester would say that there was pressure, and why he would then be involved in, in that agreement to the extent that he is involved in that agreement because of the pressure that he was receiving, and also sending it through to myself, and my pressure also from his senior. So I agree with you that it could have been a consequence, and he was feeling that pressure and exerting it on myself.
Sure, I think that is, from our part, sufficient in regard to the BR Fontaine.
Yeah, no, that's fine.
Yeah, I could then go into Dr. Nteta's meetings with one of the Gupta brothers. That should be fairly short, Chairperson.
Yeah, you can do that.
Okay.
Dr. Nteta, then
So-
the agreement is in place.
Yes.
You were relating about how the first meeting with Mr. Tony Gupta came about.
Yes.
Yes.
So I had been engaging with Mr. Nath, who is the CEO of Tageta, with regards to the onboarding of his contract, looking in terms of the volumes that are available and the general aspects of his contract. He'd requested from myself that for a meeting, and at the time I was quite busy, so we were trying to see the best time. And then I'd indicated to him that yes, I am going through to Sandton for some other meetings so that we could possibly meet. He then indicated to me, I said, okay, send me the address where we can meet, and that's what he did. I put in the address and I arrived. The place that I arrived was at Saxonwold. At arrival, it was it's a huge complex, and so I made the assumption at the time that there are offices to get us up.
Did you say
Pardon? At Saxonwold.
Did you say the
Saxonwold,
place
yes.
where you went to was Saxonwold?
Sorry, I didn't hear the start of the sentence, sir.
Did you say the place that you went to for that meeting was Saxonwold?
Yes, it was.
Okay, all right. Continue.
So on arrival, sorry, sir?
Continue.
Oh. So on arrival, I made that assumption that it is, the offices are there because it is quite a big complex. And I came in, and when I walked into the residence, I was introduced to by Mr. Tony Gupta as Tony. And I then indicated to him that I'm here to see Mr. Nath for a meeting. He proceeded to ask me some questions with regards to the coal supply agreement, the mechanics of how it works, etc. And it was really in the realm of the operations department. So I indicated to him that I normally deal with the agreements up until the agreement is signed. The questions that she's asking me about the mechanics of the agreement are in the realm of the operations department, and I then indicated to him that through his CEO, he should then engage with the operations department so that he can understand how that contract goes. And I did keep asking him in terms of where Mr. Nath is. I suspect I may have irritated him because after a few asking of where Mr. Nath is, then he then said, thank you, and I left.
I mean, the address.
Did you say he said thank you and you left?
Yes, because I'd been asking him in terms of, he'd been wanting to get more details with regards to the operations of the agreement. And to the best of my knowledge, I tried to ask and answer him. But I think, as I said to him, I think I may have irritated him because my understanding I was meeting Mr. Nath. So I kept on asking, is Mr. Nath coming? Is Mr. Nath coming? Where he'd still try and ask me about how the agreement runs. So it wasn't long, and then I left without seeing Mr. Nath.
Did he ever say what was the story about Mr. Nath and the meeting? Because one would have expected that he would call him for you if he was not there to meet with you.
Yeah. So he actually never really answered the question in terms of, you know, each time I'd ask, he sort of be a bit evasive and then ask me more questions about the coal supply agreement. He just never really answered the question.
How long would you say you took having this discussion with him?
I'm going to say maybe 15, 20 minutes, yes. I would guess.
Yes, okay. Mr. Slager.
Thank you, Chair. The address itself would have indicated that the location is at Saxon World, isn't it? The address given to you by Mr. Nath.
Yes. Yes. Yes.
Yes, this is in 2015. And would you have known about the Guptas at this stage in 2015?
Not really. Maybe they've been in the news, but I don't follow it greatly. So I would probably know who the Gupta is, but not intimately.
Yes. So you would have, or would you have become aware of media reports about the Guptas?
To be very honest with you, I don't fully follow in terms of what is happening in terms of the media. So it's a very difficult question for me to ask because I don't know. I might have known, like, okay, there's almost a company. There's an organization by the name, there's a family by the name of the Guptas, but I really did not follow.
Yeah, well, just generally, the general knowledge, not the details. So really the question is, when you are introduced to him as Mr. Tony Gupta, is the name the first time you hear, or is a name that sounds familiar to you?
So the surname of Gupta is familiar to me. Yes. Interestingly enough, he introduced himself as Tony, yes. and not with the surname. But I mean, if it's Tony Gupta. So I would understand who he is, but as I said, I don't fully follow now, how media and things like that.
Yes, how did you make that connection?
So the connection that I made was in terms of when he's also then asking me about the BR Fontaine. And I also then recall saying, well, I've seen the connection that at the time, I did not understand that they were part of Oak Bay. So I remember just thinking, okay, this transaction, the shareholders, it's Oak Bay and some other individuals. I think it was some lady, etc. So then I got an understanding that, okay, this is a shareholder. And I think he did say I'm a shareholder within BR Fontaine, and I want to understand the mechanics.
Yes, but my question is, if he introduced himself to you only as Tony, how did you make the connection that he's Tony Gupta?
So he said his name is Tony. Yes. He may have said later on, Tony Gupta, I'm Tony Gupta, but in the interaction, he would always say Tony. So I made the deduction that Gupta must be part of the Oak Bay and then also part of the transaction. And I do believe he then said to me, I'm a shareholder in terms of the BR Fontaine.
Yeah.
When you saw the address, which included Saxon World, do you remember whether that might have given you the idea that this could be the Gupta residence at the time, or is that something that didn't click with you at the time?
So on getting the address and saying Saxon World, yes, I understood that it could be their address, but also understanding that that's probably because I didn't actually know where the Tegeta offices were.
Yeah.
So then just thinking that it could have been in that area.
Mm-hmm. But as you were interacting with Tegeta, you knew the connection between Tegeta and the Guptas, or did you not know it?
So my first, I'm going to call it a light bulb moment, was actually at the end of the agreement, the negotiations. So then it realized that, okay, this is Oak Bay, this is Oak Bay, Tegeta, Gupta, and that really was at the end. But in my initial negotiations with them, I actually did not put those two together.
But you say.
But by the time that I did meet them,
yes.
I had then understood that.
Yes.
Because also there was media. I mean, I'm not going to say that I did not know totally. I did.
Okay.
Yeah, thank you, Chair. So that would have been before the conclusion of the agreement, which is 10 March 2015, that you would have had this knowledge about them.
I'm actually going to say probably at the end of it, so probably about April, May, after the agreement. So prior to that, not really. And as I said, I'm not one to be following a lot in terms of the media.
Yes.
But from March onwards, I actually want to say around about May, but I stand to be corrected.
Yeah. Well, to the extent that you knew about them, Dr. Nteta, prior to this meeting with Mr. Tony Gupta, well, it was a meeting, as you say, intended to be with Mr. Nath, but it ended up with Mr. Tony Gupta.
Yes.
Did you make a decision that this meeting will never take place, or a meeting such as this will never take place again? In other words, that you are not going to have a meeting anymore again with Mr. Tony Gupta or any of the Gupta brothers.
So when I left there at the time, I was annoyed that I had been summoned there believing that I was meeting Mr. Nath. So that was more, if I can put it, that my irritation with regards to that. And that was my sentiment at the time. I didn't engage as to whether I would meet them again or not meet them again at all. It was just more why was Mr. Nath not there?
So in paragraph 9.3 of the affidavit, page 82,
Yes.
You refer to what he talked with you about, Mr. Tony Gupta. So you say he proceeded, the third sentence, he proceeded to ask me about coal sampling processes and predominantly coal operations processes, I beg your pardon, coal operations processes at Eskom.
Yes.
Please tell us what are these topics about? What exactly is he
So when I
raising?
say so in the discussion that I had with him, it was when I say coal operations, I'm talking about the coal supply agreement, the operations in terms of the mechanics of a coal supply agreement. So in terms of BR Fontaine, how do they go about sampling? What is the process in terms of sampling? How is the coal supply agreement? What are the operations and the mechanics in terms of executing the contract?
I see. So he wants to obtain information from you on how the contract, well, let me put it this way, on what is entailed in the execution of the contract.
Yes.
Is that right?
What is the process and the procedures? Yes.
But these are things that a supplier is expected to know, isn't it?
So yes, what tends to happen in terms of Eskom and the engagements that I've had with coal suppliers is that you have coal suppliers where there's the operations and you'd have the executives within the organization, the CEO, the COO, and those who are running the mine per se. And it's oftentimes different from the actual shareholders. So for whatever reason, there are some suppliers, for whatever reason, the operations versus the shareholders, there's a disconnect, and the shareholders may feel that we want to know more, we want to hear it from Eskom as to how things, the mechanisms of the agreement, whether they want to verify what their executives are saying, etc.
Yes.
So the executives would know how to execute the contract, not necessarily the shareholders.
Yes. No, that's correct. But if a shareholder wants to meet with you, the shareholder is not going to trick you into you thinking that you're meeting Mr. X, and then you suddenly end up meeting the shareholder. You're going to know that I'm going to meet the shareholder.
Normally, I will know that I'm going to meet the shareholder, yes.
Yeah, I'm saying
because
if
the shareholder would contact me.
Yes.
Or sometimes I'd meet the CEO would say, or let me say the executive would then say, I would like you to meet with our shareholder.
Yes. So you would know.
He wants to. Sometimes,
Yes. The point is, you would know beforehand that the request is for you to meet with the shareholder.
Yes, I would be told that if it's, normally I'll be told that either by the executive or by the shareholder contacting me directly.
In this case, you were not told.
No, I was told that I was meeting the CEO. The CEO requested the meeting.
Yes. And it really isn't Eskom's business as to what's happening between the executives of a supplier and its shareholders. Isn't it? I don't want to say it's not our business per se, because we've had situations, if there's there's a disconnect between the two, it can jeopardize the potential for us to supply coal. So if there's disgruntlement, etc., it then affects us in terms of the security of coal. And one of our biggest mandates from the fuel sourcing perspective was security of supply. Yeah, but in this case, you know nothing about the concerns of the shareholder. They haven't been raised with you beforehand. You haven't been told that, look, the shareholder has X, Y, and Z, which is of concern to him or her or them, and would you please address the shareholder on such a date at such a meeting? This meeting arranged is between you and the CEO. And
Yes, so at the time, I didn't know there's a disgruntled shareholder, no. But it's not uncommon that there would be a disgruntled shareholder.
yeah, but you haven't said here that he's disgruntled. He doesn't seem to be disgruntled here. He's actually asking you information.
No. Yes.
Okay. Yeah, so there's no disgruntlement. He's simply asking you information. That seems to be information of more operational, at the operational level.
Correct, of his agreement, yes.
Yeah.
When I say disgruntled, I made the assumption that sometimes there are shareholders that are not happy in terms of
Yeah, but just confine you to
the
this one.
mechanisms.
Just confine
Yes,
you
sorry,
to this one.
apologies. No, he's not disgruntled. He's just trying to understand
Yes.
the mechanics of his agreement.
Did it not surprise you? Well, you say you were angry or upset. Did it surprise you that he was asking information at that level of operations?
It didn't surprise me that he's asking that information at that level, because I've had some shareholders ask me in terms of take me through, how to get a contract in terms of Eskom, what needs to happen. So his questions didn't surprise me because I've experienced them before. As I indicated, sometimes it's because the shareholder feels that he's not getting relevant information from his employee.
Okay, then you do relate in your affidavit a second meeting with Mr. Tony Gupta. Would you please tell would you tell the chairperson about that one?
Okay. So the second meeting, I was called by by Tony.
Well, I'm sorry,
to meet with him.
Dr. Nteta. Before you
Yes.
talk about the second meeting, for the sake of completeness, tell me whether subsequent to your first meeting with him, which was meant to be a meeting with Mr. Nat, whether you connected with Mr. Nat or he connected with you, and what was his explanation for not turning up at the meeting?
So I did have quite a few engagements with Mr. Nath. So I did indicate to him that he needs to take, that I met with his shareholder, and he needs to take him through the process of the coal operations, and also that perhaps he needs to be meeting with the coal operations team just so that he can understand it.
Yes,
And,
but the
and
first,
Mr. Nath then said, yeah, no, it appeared to me that Mr. Gupta is the one who wanted to meet, so he says no. So I got a sense that that was the intention, that he wanted to get an independent view.
okay. Were you mistaken in understanding prior to going to Saxon World, in understanding that your meeting was with Mr. Nat?
Yes, I was mistaken.
So the intention on his part, that is, Mr. Nat, was that you meet with Mr. Gupta, as you subsequently understood.
Yes.
But why wouldn't Mr. Tony Gupta have said to you, no, you are meant to meet with me, not with Mr. Nat? You kept on asking about Mr. Nat, and he never said, what are you talking about? I'm the one you are supposed to meet with. Did you ever understand why he wouldn't have said that if his own understanding too was that you were there to meet with him?
I can't speak to that. I can't speak to his understanding as to why he didn't just tell me.
But are you saying that Mr. Nat did explain why he didn't pitch up for the meeting, and he explained it on the basis that you must have misunderstood the meeting that he asked you to go to was a meeting with Mr. Tony Gupta?
Yes, so I just asked, and it appears to me that that was the intention.
Yes, but
that the intention was for me to meet with Mr. Gupta.
But is that
the intention
because,
of both parties?
Is that because that's what he told you, Mr. Nat, or is that because you didn't ask him directly, why did you not turn up at the meeting, but you inferred that he was not meant to meet with you?
So I asked Mr. Nath in terms of, I said, you'd requested the particular meeting, you were not at the meeting. And he indicated that Mr. Gupta is the person who wanted to meet with me. And I said, well, he was asking me in terms of information about coal operations and things like that, which firstly is not within my area, but also it's something that I felt, you could explain to him. And then he did indicate that, he wanted to understand it and, wanting to understand that particular agreement. And so that's why I'm saying to you that there was the intention that I meet with him. From both of those, from the two individuals.
Yeah, it's very strange. Yeah, okay, all right.
Yeah.
Maybe it's not so important.
Yeah, but Dr. Nteta, what the chairperson was trying to establish with you, and I think you gave an answer, but you didn't appreciate the question. The question is were you mistaken? When Mr. Nath is asking you to come to a meeting, are you mistaken that it is Mr. Nath calling you, or you know that it is Mr. Nath calling you for the meeting?
So Mr. Nath, I'm not mistaken that it's Mr. Nath, because he asked to meet with me and he made the arrangements to meet with me.
So,
and because I've been engaging with him,
yes.
It was my understanding that I'm meeting with Mr. Nath.
Yes. So you're not mistaken, as if you read incorrectly the request for the meeting. You understand what I'm saying?
No, I don't.
You didn't read incorrectly that, oh, I thought I was called to the meeting by Mr. Nath, but now I see the request was actually made by Mr. Tony Gupta. You follow?
But Mr. Gupta didn't make the request.
Yes, okay.
It was Mr. Nath who contacted me.
Okay.
It's just strange. It's just strange to me how it would be possible to have that kind of misunderstanding. Mr. Nath is the one you had been dealing with. I think from what you are saying now, you were not mistaken that the interactions or discussions you had with him were to the effect that you were going to meet him. Am I right?
Yes. That was my understanding.
Yeah, and one would have expected that if he was not going to meet with you, he would have said so expressly to say, look, there's a need for a meeting. It's Tony Gupta who wants to meet with you. I'm not going to be able to be there, but I'm just setting up the meeting. This is what he wants to talk to you about. One would have expected that to be something quite clear. Then have a situation where you come all the way on the basis that you are meeting this one person. Even as you are talking to Mr. Gupta, you keep on asking, where is this person? And he doesn't say, why do you keep on asking about that person? Because you are supposed to meet with me. He doesn't say that. You actually end up leaving and you are unhappy because you haven't met the person that you were supposed to meet. And he doesn't say, I'm sorry, you must have misunderstood. Didn't he tell you that you were going to meet with me? He doesn't say any of those things. Can you see what my difficulty is? The natural reaction one would have expected from him, if he knew that you were meant to meet with him and not with Mr. Nat, would be when you asked where Mr. Nat was, look, you are supposed to meet with me, not with Mr. Nat, or he's not coming, but I'm the one that you're supposed to meet with you. Didn't he tell you? That's what one would expect. But from what you have said, he kept on avoiding telling you about where Mr. Nat was until you left. Just the whole thing. It's strange that in the arrangements, you would think you were going to meet with Mr. Nat when actually that's not the arrangement. And then it's strange that when Mr. Tony Gupta was having this discussion with you, while you kept on saying, where is Mr. Nat, that's the person I'm supposed to meet, that he never says, no, but you are supposed to meet with me. I'm the right person that you are meeting. He doesn't say anything of that, but keeps on asking questions. And from what you say, it looks like he avoids giving you direct answers about Mr. Nat until you left and you are unhappy. You understand why I find it strange.
I hear you, Chairperson.
Yes. Okay, but in the end, maybe it might not be important. Mr. Sileka?
Dr. Nteta, do you know, to the extent that you say you gave only general information and you encourage Mr. Tony Gupta to engage with primary energy of Eskom, whether that happened? Did he engage with primary energy?
I don't know. I don't know.
Okay, let's go into the second meeting then. Relate to the chairperson.
Let's not go to the second meeting because it's 5 o'clock now.
Oh, is it 5?
Yeah.
Oh, okay.
So let's go to the second meeting tomorrow morning at 10. Just make sure that Dr. Nteta has got a copy of the mandate that she talked about earlier. Just make sure that she has got a copy of the affidavit of Mr.
Bester.
Bester.
Yes.
And any other documents or affidavits that she may need to have sight of that may be relevant for her evidence tomorrow.
Yes, Chair.
Yes. We are going to adjourn now. Dr. Nteta, do come back at 10 o'clock tomorrow morning. Is that fine?
It's fine. Do I use the same link?
I think they will let you know, probably the same, but they will let you know. Yes. They'll contact you, the technicians will contact you. Okay, we'll then adjourn and then we'll resume tomorrow at 10.
Thank you, Chair.
We adjourn.
Thank you. Thank you.